My diamonds in my hand. But the strong breeze could not equal to the rain. I wish I stay in Christ. I'm praying for my days. My source of strength, my source of life in Christ alone.
Is that better? If you lift it up a little bit, so that I can actually, yeah, it's still down. It's still down. The light is quite strong. Maybe you can come in and see. Yeah.
And to count my years, my losses, to grow.
your MC and host for today's dialogue, focusing on child maintenance. And today we are going to be delving deep into the topic of international child maintenance. I just want to quickly highlight some few house rules. This session is recorded and will be available. Afterwards. It's recorded on StreamYard. It's available on our YouTube channel, Facebook, as well as Facebook Live on our community dialogue page, and it will be available on our website, www.childmaintenance.org.za. We do have parking around this building. If you have not parked on the parking that's reserved for public prosecutors, please speak to one of the ambassadors so that you can move your car, otherwise you're going to pay for parking for today. And we do have bathrooms on this floor. Just ask one of our ambassadors to assist you. We also have refreshments at the back. Today we don't have lunch served in the cafeteria, but there are refreshments at the back. The tea and coffee is once ready. I believe she's already. In the deep value of Ubuntu. We are recognizing our shared humanity. We are here to support each other. We are here to uplift each other. And if you are new here, I want to remind you that in this platform, you matter. In this auditorium platform, NPA soccer community, your voice matters, whether you're a father, a mother, a legal practitioner, a social worker, a leader in your community. In this platform, your voice matters. In this platform, we need your voice. What do you have in your hands today? Sir, ma'am, that you can bring to this community for us to see the transformation that we are fighting for in the justice system. We are also here to empower each other, to educate each other. We are here to share the little bit of resources that we have, the knowledge that we have to create the change. We are also here to bring light to all the preventing us from actually seeing the change that we want to see. How do you defeat an enemy that you can't even name? This platform gives language to our experiences, gives language to those challenges. And I believe that once we at least have a bit of light and language, we will be able to start to create or curate solutions that will bring about the change that we are fighting for. Our aim is not to exclude anyone from this platform. We want to bring together the parents, the fathers, the mothers. We want to bring the legal practitioners, social workers, lawmakers, policymakers, community leaders because this is such a powerful platform and we have already seen the fruits of the power in this platform. But as we continue in our efforts, let us not forget our why. Why are we here? Why do we come every Saturday, last Saturday of the month? We are coming for our children. We are coming for the future of South Africa, ladies and gentlemen. It's raining outside. We could have just stayed at home, but we are here. Why are we here? Because of the future of our children. The decisions that we are making today, ladies and gentlemen, will have a lasting impact on our children, on the future of this nation. So, as we lean in today to just glean on the wisdom of the incredible speakers, by the way, we are so honored in this community. I mean, the caliber of speakers that we get to have every month coming to pour their hearts, to pour their gifts on this community freely is absolutely incredible. And I just want to take a moment and just honor the incredible speakers that are here today, who are here to pour what they have for us. And I want to encourage each and everyone in this room and those who are watching online, please approach this dialogue today with an open heart, with an open mind. Allow their words to fall on fertile soil. Allow their words to move you. The sessions are very difficult. Sometimes we get triggered. Last month, I was sitting there weeping. It's painful. It's uncomfortable. It challenges the norm, the normal narrative. But I would like to encourage each and every one of us, ladies and gentlemen, to just approach this with openness and trust the process. Once again, thank you so much for taking time to join us, and those who are watching online, thank you so much for tuning in and joining us today on this very special dialogue focusing on international maintenance. So before we start our dialogue today, I've been asked to just do a bit of a recap on the dialogue that we hosted here last month. We focused on the voice of the father in the maintenance system. This deep and complex topic was thoroughly explored by the incredible speakers that came, and they delivered meaningful, thoughtful, enlightening, and heart-wrenching discussions. But unfortunately, ladies and gentlemen, it just became apparent that before we even touch on the subject of the voice of the father in the maintenance system, we must first confront the underlying issue of fatherlessness in South Africa. Mr. Daniel Den Hollander painted a clear picture of the impact of apartheid and its aftermath on fathers, which, as we all know, we cannot underestimate. The trauma, the emotional toll of living under such a repressive regime had lasting impact on individuals and the family dynamics of this nation. And we cannot overlook that. The fatherlessness crisis, ladies and gentlemen, is extending far beyond mere statistics. It's tearing the very soul of our communities. Throughout the presentations, it became evident that actually there is an urgent call to call the father back home, to call the father back to communities. And that's going to take our collective effort. That's going to take us opening our hearts to a different story, a different narrative. Our very own Miss Natalie Ratis delved into the topic of, actually this topic is hidden in the shadows, the topic of parental alienation and the impact that this has on fathers who actually want to be part of their children's lives. But she also brought it back and said, there's also hope. And she showed us how mediation can be used as a powerful tool to navigate the complexities of co-parenting. We were given glimpses of hope, ladies and gentlemen, by two incredible fathers who are setting an example. Mr. Gerald Mohammed and Mr. Chris Exton, sharing their stories of fatherhood and showing us that actually it is possible. Against all odds, it is possible. I was particularly touched by Mr. Exton's story of how he surrendered his Ellen Gray annuity retirement fund just so that his children would be provided for despite the impact of COVID on his finances. And I want to encourage fathers in this auditorium and those who are watching online to follow such an example. Don't wait for the mothers to approach the courts. If you know that you've got retirement annuity, there is a way out, and Advocate Dion Reuters will be delighted to assist you with Section 30 attachment. With that said, with those examples, because we only had two fathers that spoke and we were encouraged, but again, ladies and gentlemen, it is evident that we are not ready to even start planting seeds to see the change that we want to see. There's still a lot of groundwork that needs to be done. And that's why I'm comfortable to bring this in this auditorium, because I know in this community, we are open to the new. In this community, we are open to a different narrative. In this community, we are open. We are open to exploring. Last night, I read one of the presentations, one of the guest speakers here today, Dr. Kamel van Nieuwkerk, and I was heartbroken. She comes from the UWC private law clinic, and she suffered in the maintenance system. And I was like, icon. Something has to shift, ladies and gentlemen. A doctor in law suffered in the maintenance courts of this nation. Something needs to change. Something has to shift. We cannot continue the way we are continuing. And I believe each and everyone in this room and those who are watching online, we do carry something. And that's something that you are carrying in your heart today is enough to bring to this platform so that we can start creating solutions for this matter. Because clearly, if a doctor can suffer in the maintenance system, who am I? Who are you? So, the cry of my heart as a mother in this community is just, is it possible for us, firstly, to establish a safe environment for fathers? Do fathers have a space in this community, ladies and gentlemen? Do fathers have room in this community to come, to get empowered, to get educated so that they can become better fathers? Do they have space in this community? Do they have space to navigate the complexities of fatherhood and manhood and masculinity and heal without being judged in this community? Because out there, I know there is no space, but at least this community has fostered a different culture, a culture of compassion, a culture of empathy, a culture of understanding, a culture of forgiveness and reconciliation. Is there room for the father in this house? Do the fathers in South Africa today have a script? Mr. Daniel Den Hollander highlighted that where is our script as men? How do we navigate the complexities of manhood in 2023 after everything that this country has faced? Is there room with all the gifts that are in this house where we can rewrite a script for the men of this nation, for the fathers of this nation? I believe in this room today, those who are watching online, there is someone here who has a gift that they can bring to the table so that we can start rewriting the script for the fathers of this nation. And I want to encourage us, there is hope. Because Mr. Customs, even though he came and highlighted the plight of fatherlessness in South Africa and unpacked the devastating consequences of fatherlessness, he also gave us a model. His organization, The World Needs a Father, it's a global organization. They are helping governments and communities all over the world to tackle the matter of fatherlessness. There is hope. There are resources. They are training fathers and families all over the world, and they are seeing the change. So I do believe that if we continue to do what we are doing, we will curate a new narrative for the sake of our children. Because I believe we are all here because of our children. In the words of Miss Natalie Ratus, we are journeying together, bringing our hearts and wounds while crafting a different reality for the next generation. If you'd like to watch the full dialogue, it is available on our website, www.childmaintenance.org.za. Okay, we're going to start our program today. And to kick off our program, we are honored and absolutely privileged to welcome Judge Daniel Tulare today. He is currently serving the nation, ladies and gentlemen, as a judge in the Western Cape High Courts, and he's continued to serve. He served over decades as a judge. He was an interpreter, a prosecutor, and a magistrate in South Africa's family courts, and he's really played a role in transforming SA family courts. Ladies and gentlemen, Judge Tulare will now speak about the rights and the responsibility of fathers in the maintenance system. Ladies and gentlemen, can we give Judge Daniel Tulare a warm hand of applause, please?
Good morning, colleagues and friends and families that may be watching these proceedings. I am humbled and honored to be invited to come and speak today as we try to be true to our generational mandate. I always say, at times, we have to sit back and reflect on where we come from as a nation, where we are, and where we are heading. And despite the challenges and the dust of the arena in which we find ourselves, we need to ask ourselves, what has happened in the country? And what is happening now? And what type of South Africa is it that we want to have a footprint in bequeathing to our children and our grandchildren? And I think if we move from that premise in engagements, we will realize that the pains and tribulations of the time do not actually matter in the greater scheme of things in terms of the mandate of our generation. So that ultimately, when those who write have occasion to sit back and write and say, this was South Africa in pre-1994. And this is the South Africa of constructors of a constitutional and democratic dispensation. And perhaps the ideal that we are looking forward to realizes, and they live in that space and they look back, will they see your footprint in the nation at work for a better life? Or would they find a forever complainant in a corner? So I am approaching this talk on that understanding to enjoin everyone to say, in my view, the mandate of our generation is to construct a better South Africa that we would want to live for our children. And then we must be brutally honest in discussing what happened, what is happening, and what should happen as we look forward. So my sister asked the question, is there a script for men? And in a way, I think she was prophetic because I'm here to speak on what, in my view, we should start contributing to the script that is there. And I have to start by saying, never mind the religious debates. All right. But I'm a Christian. And the purpose and the intention is not to convert you to Christianity, but to say there is a script found in the Christian book that we must look at as part of the contribution of the script of a father. And then we must try to work with other religious persuasions on perfecting that script. And the script is found in the most read book of those in the Christian faith called the Bible. And it is in the book of Matthew, chapter 6, verse 9. It is commonly referred to as the Lord's Prayer. And I will go with you through the Lord's Prayer, not as a sermon, but as part of our discussion of what is a man and what type of a man are we trying as we emerge from apartheid South Africa into a constitutional and democratic South Africa. What type of a man are we looking at our kids and our grandkids to be? Now, it starts with our Father. Our Father. You can't be a man, all right, if you only think that your responsibility is only to your biological kids or only your biological kids within a marriage, and or, as you narrow down your responsibility, every child in the street, every child in your community must be able to say, our Father, when they look at you. They must be able to own you up. And that speaks to your outlook. It speaks to your character. it speaks to your understanding of your purpose. You are called upon not only to father your biological offsprings, you are called upon to father the nation. And that's the first point of departure. So every one of us, when we look at you, we must see a father. We mustn't see a factory fault. All right? We mustn't see a factory fault. South Africa's factory fault. We must see a father. All right? And the book goes on to say, who art in heaven. Which means you have a responsibility to have what in law they call a domicilium. All right? A place. All right? And what am I saying? You can't be a father and call yourself a father in truth when you haven't bought a door frame for your children to walk into a home. Because most of the debates and the fights amongst communities, especially in South Africa, and more especially in Cape Town, where there is a serious battle for land, especially for the Black communities, right? Because land is so expensive, all right? It becomes difficult for fathers to provide a home. We understand that. But it should be an ideal that when you are a father, you koop your eie kosyn. You can't be marrying and bringing your wife into your parental home and have fights where you actually debate on pieces of a chicken to say when she has cooked, she gives only my children the wings and she gives her own children the thigh. I mean, why do you allow that kind of situation? Buy property if you can afford it. Get out. And we must speak out these things because they are at the center of family fights and they are at the center of disputes between companions, and sometimes the relationships end because he doesn't want to go and buy his own door frame. So you must provide a home for your children. A separate estate from the estate of your parents and the estate of your siblings. That's the responsibility of a father. You can't have a situation where, and these are the battle within families. When you pass on, there is now a debate of who owns what. Your wife and kids end up in the street because ye etni ekoseni hakuapi. Aso reke koseni. Autengangi koseni. Usapili. So we must speak these things out. Fathers must take responsibility. It doesn't matter whether it is a child in marriage or not. If you can afford it, buy your kids property. If you happen to father children with more than one woman, if you can afford it, make sure that each and every one of them have their own home. So that we know when you are called yonder, right? There's no debate as who stays where and who owns what. Hallowed be thy name. Hallowed be thy name. Can we actually, when we see you and how you behave, say, wow, that is my pa? And that speaks to the character and the reputation that you build. All right? You can't build that wow element if when other fathers are spending sleepless nights reading and writing assignments, you are at a tavern. It can't be. It simply cannot be. To build the wow element as a father, you must be able to know what some of us know. You can't lead the nation if you sleep the same day you woke up. It's simply impossible. Those of us who are toiling to build a better South Africa, most of us do not sleep the same day we woke up. And if you ask me who are the characters in generations, I don't know. And I'm not saying SOPs are bad. All that I'm saying is, if you still have time to follow Idroslami or Seven the Land every day, something is wrong with your fatherhood. Seriously wrong. There must be time, and don't hear me wrong. There must be time where you sit with your family and enjoy family time. And on that occasion, you will have to watch Seven the Land. But either during the session or thereafter, you must have a briefing of what happened before and what's likely to happen or what happens 2 weeks before. But if you follow it every day, there is something wrong with your fatherhood. Because it means you've neglected building up the wow element. Because the wow element makes it impossible for you to have your whole life as an entertainment period. It can be. The time to entertain yourself and your family is very limited as a father, but it is necessary. It is necessary. Thy kingdom come. What is it that you're teaching your children? Do your children actually know what matters in life? And do they hear it from you? Because you see, I'm standing here. I don't have to worry about my kids' choices today, where I am. I don't. And the reason is, in my view, I gave myself time when it mattered most. And the time that matters most with kids is very limited. All right? Between the ages of 9, in my view, and 14, that's the only time that you have as a parent. That time, in my view, between the ages of 9 and 14, if you can't make it, it's gone. It's gone. Because before 7, they may not remember. They may not appreciate. And if they are in school, whatever the teacher said, it's number one. Whatever you say is wrong. I mean, those who raised kids who were school and have been of school going age, once the teacher has said it, that's it. All right. So at least from 9, there is an understanding. But after 14, you start competing with the streets. That's the reality. Sometimes, if you are not fortunate, even earlier, depending on their development. So you have, as a parent, very limited time to put in your value system, your norms, what you expect of the kids, the capacity to make up their own minds. And this is very important. The capacity for children to make up not fearing you as a father, but being able to make up their own minds to say, I won't take a fag because it is wrong. Not because my father would beat me up. All right? Because it is wrong. So you have that limited space. And that's your kingdom. That's what they are also going to transmit to their children. And that is why some of the things you have to teach them. I mean, sitting back and thinking, if we took the time that we are taking either on the Saturday or the Sunday to take and sometimes even force our kids to go to our religious places of worship, if we took that same energy to teach them about financial management, how far would they be by the time they reach matric? Because some of us, like me, I grew up in a rural village. The mouse that I knew is the one that runs amok in the house. I started seeing a mouse that's electronic when I joined the Department of Justice. All right. So if we took the same energy on other things, and don't hear me wrong, I'm not saying there is something wrong with taking you, with you making time 2 hours or so every week to the pastor. I'm not saying there's anything wrong with it. But just reflect. If it's a 14-year, 15-year-old, if you spend the same time every week teaching that child financial management, would that child ever appear on the debtors lists? And what is it that matters to you? I mean, I had to get a CV prepared. All right. In my time, even to join the Department of Justice, you still had to get a referee. So I had to go to the pastor and say, give me a reference letter to say, hey, can come altyd Sondag kerk toe. All those things, all right, to convince the government of the day then to say, I'm an upright person, a khoini klepeni. All right. So what is it that when you leave, and deliberately I'm talking about other issues except the financial part of the maintenance of a child and the building up of a community, how the voice of the father matters. All right. So build your kingdom. Build your kingdom. Your children, you may not get it right at all times, but at least try your best. And I always believe that luck lies somewhere within hard work. Luck lies somewhere within hard work. So just work hard and you may trample around luck and things may change for the better. So build your kingdom. Check on what matters. Check on the norms, the values that you have a responsibility to bequeath to your children. Thy will be done on earth as it is in heaven. Make sure that whatever you wish to happen tomorrow, you build today. Whatever you wish to happen tomorrow, you build today. You can't be beating up your wife and kids and expect to have a child who doesn't believe in violence as a form of solution to problems. It doesn't work that way. I always remind myself to say the best sermons are lived. They are not preached. It doesn't matter what you tell to anybody. What matters is the lifestyle that you lead. So how you behave to others. I mean, I wake up in the morning, you're my neighbor. Your child is listening whilst you're complaining that your neighbor is talking to you too early. You know, you still want to collect yourself and she's making noise. These nasty comments, your child is listening to them. Your neighbor may not hear that you're complaining that you're greeting them too early in the morning, but the child is listening. And that's what you're building up. That's the type of character you're building up. So be exemplary in how you conduct yourself. Be exemplary as a father in how you conduct yourself. Give us this day our daily bread. This is the main thing. All right. Die wet van Transvaal, betaal omat. To the extent that you are able, provide for your children. It does not matter. I always say, you see, when dealing especially with maintenance recovery, generally, you're dealing with people who love each other. At one point, they declared themselves the best match made in heaven. Sweetheart, high gate of Jerusalem. Only you and I can climb. Yeah, I remember in my school days, you know, when we didn't know English, so just to impress you, just wrote everything. No, I'm still gogolizing under the magogability of my tontability. As long as the abilities, you know, just to impress. So that's where the relationship comes from. All right. Sometimes you believe you are cut from the same cloth. Sometimes you believe that you are specifically designed for each other. God set you here as a father and looked at you and cut out hair for you. And something went wrong. And then you realize that the line between love and hate is actually very thin. All right? And then there comes the pain then of how you deal with how you separate. You become nasty to each other. So there is pride, there is pain And those things are not part of the papers that comes before a magistrate or a judge. All right. But that baggage is there. And it defines how then the parties approach the question of rents and cents. So my plea, as we write the script of a father in 2023, is that remove those spectacles of your pain and ego through which you see the children. Remove that mother, put her on the side so that you can see your children without the blurring of your pain, the blurring of your issues. The fact that she cheated has got nothing to do with your children. Has got absolutely nothing to do with them. The fact that you decided to say, okay, this is enough, I'm walking away. Walk away from her, but not from them. You see? So the responsibility to provide is still there. And you see, the law, when you are called to court as an accused person, is that you have the right to remain silent. All right? And that right is even in the Constitution. It's constitutional guarantee. But when it comes to maintenance, the law is different, because the right to remain silent is in Section 35 of the Constitution. It deals with an accused person. When you're called for a maintenance inquiry, you are not an accused person. In fact, the regulations say you have a duty to speak about your finances. So there is a distinction. Whilst you have the right to remain silent when you are accused, when you are called for a maintenance inquiry, you have a duty to speak about your finances and disclose. You don't have to hide your finances. You don't even have to wait for a maintenance officer to ask you for that. In fact, when you're served with the documents that calls you for an inquiry, you will see that that document includes what you have to disclose. And if it is more than what is set out there, you have a duty. Frank and candid, these are your children. They must be provided for. They don't eat excuses. We can't clothe children with your excuses, however cogent they may sound. Betalo mat, lefarra, kokandot. Forgive us our trespasses as we forgive. This is very important. We must have the capacity to transcend pain.
Yes.
I have said there is what I call the generational mandate. And the mandate of this generation is to be able to transcend the pain. And transcending that pain does not depend on who caused it. I don't have, and I didn't even need F.W. de Klerk's apology. Are you with me?
Yes.
To forgive apartheid South Africa for the losses and the pain that I suffered. You see? Even those today that still deny that today, myself and my people are still suffering from the past. I don't need their understanding. Are you with me? I'm the bigger person. Whether they realize, all right, that still putting blacks in modern day concentration camps, placards campe, you know, and blackies dorpies, all right, whether some still have the humanity to see that that is wrong. You can't have a situation where more than 80 families share one toilet in a city like Cape Town. Whether they see that as something that is painful or not, I don't need them. Are you with me? I don't. You don't need an apology. You don't need an apology to forgive. But that does not mean that you don't have the right and the duty to speak out when you are in a position to speak out. You see? So you, as a father who may have gone through the pain and may still be going through the pain, all right? You have a mother of your children who's born again, Bible bashing, all right? And then your belief system is different, all right? There must be because you believe in sangomas and traditional rituals and whatever. And then during the drum beating, someone in a spiritual trance says to you, look, the problem is your ancestors are not happy because you're not taking care of your children. So you must bring all your children home and appease your ancestors by slaughtering a goat. All right? And then you go to the mother of your children and say, hey, I need my kids home. I'll be slaughtering and they must come. Says, I'm born again. I don't need that blood because Jesus' blood is sufficient. Don't need goat's blood. Even if that hurts you, it does not mean that you don't have to pay maintenance the next month. It doesn't mean you don't have to pay maintenance the next month because the children's courts are there to discuss issues of contact and care. All right? And what is needed? It's education to both the father and the mother to say, look, expose the children to all different persuasions of religious beliefs and faith. Expose them. Let them read the Quran. Let them read the Bible. Let them attend the drum session. All right? And so that they are enlightened and they reach a position where they can make up their own informed decision as to their faith if they elect one, or even to say, these things don't work. Hell and heaven are here on earth, and that's it. There's no afterlife. It's for them to make those decisions. You don't have to impose your own views on them. All right? So it is important that you transcend your pain. You are able to see beyond what caused your pain. Your pain is no justification for not having a relationship with your children. And you'd have seen from my discussion to say, I deliberately went through, and also the chapter helped me that it put maintenance more towards the bottom. Not that it is not important, all right? But there are other things that matter in the development of a child that needs the father, all right? The values, amongst others. They need the father. That is why it is important that we encourage fathers to have relationships with the children. All right. We are not saying they must go kiss and make up with their mothers. If you have been kissing a frog for 30 years and you decided after 30 years to say, I'm kissing a snake, let it be. It's okay. It's okay. Remember in my profession, and especially in my previous life as a magistrate, I knew that there is a period where there's a transition, you know. In the part that I said, people believe that they were cut from the same cloth. It's baby and honey. That's how they call each other. Baby, honey, you know. But once that crack happens, all right, then they change. And normally the names are similar. All right. The woman becomes the snake, the man becomes the dog. All right. So after 15 years, you realize I've been sleeping with a dog. Or I've been kissing a snake. I'm not saying go and kiss the snake, but those children remains your children. And they need your love and care. They need your support. Lead us not into temptation. All right? There's one thing I have observed in my time in the magistracy told me that sometimes the worst enemy of a woman is another woman. The worst enemy of a woman is another woman. Because you have instances where the father took care of the children during the relationship. And then there was a breakup, and he still continued until there was another woman in his life. Until there was another woman in his life. And sometimes you can discern even during the inquiry that actually he himself understands the true issues. All right? But he has got a fear of what's going to happen in the bedroom that evening in his new life, or even when they walk out of the courtroom. And that is why sometimes as a magistrate, you have a very serious difficulty, and you think very hard, because there is an application by the father to say, I'm now married, and what we are going to discuss has got financial implications in my new life. I asked the court to allow my new wife to be present in the proceedings, to take note of what is happening, and also to give me moral support. What do you do? It's not an easy question. All right. And sometimes you discern that there is temptation outside on the father not to be true to his obligations because influences come somewhere. I'm not saying it always comes from the other woman. Sometimes it comes from his own siblings, and sometimes from his own parents. There wasn't a good relationship between the mother of the children and the sisters of the father or his brothers. And now that they've broken up and there are issues of children, there is an opportunity to fight back. So they hit over his shoulder at the woman. And because they can't reach, they hold his hand and, jab her. So you find that you are influenced as a father by external pressures in relation to your own children. People use their own fights and pains to use you against your own children. And as fathers, we need to guard against that. I mean, let's be frank. I am yet to see a married man who makes up his own mind, according to women around us. All right. I'm yet to see that. I mean, if you're a married man, you know that, or you can relate that some of the decisions that you make, when you discuss them with your wife, you will get the accusation that they come from your siblings and or your parents. Similarly, when you discuss with your family, you're being dragged by your nose by your wife. So we often don't have the space to think for ourselves. In respect of women around us, we are always thoughtful. So you have to make up that balance as a father. All right? You have to make that balance because there is always competition for you. The competition that comes from people around you. Everybody wants to be the center of influence on you. All right? And yes, your siblings love you. And your parents love you. And it's a different kind of love from your wife and children or your children. It's a different kind of love. So it is true that when you come home, they'll start from whether your shirt is creased, well ironed, whether you're developing a boob, because of the gravy where tomatoes are not well cooked. And acid is rising inside, we don't know. Or whether it's because you're well fed, we don't know, but you're developing a boob, all right? And they start getting worried, So it's natural. They love you. Remember, your mother has been ironing for you since you were born, all right? And she knows how she used to present you. And you may be married to or have a relationship with a woman who's not so good in ironing. Just as much as you may be married to a woman who's not so good in the kitchen. All right? So the concerns about how you're fed, especially if you have a mother who's or parents who are very careful about your diet and what have you, and they realize, yes, I can eat. All right. So there are those kinds of debates. So there's always that temptation around you. There's always those battles that you must fight. But you must, as a father, always triumph over them for the sake of your children. It is important. You have to manage your family and divert their interest to know that when it comes to Daniel Tulare with his kids, it's a no. They must know the answer before even they approach you. All right? They must know that with his kids, you must convince him to get a yes. The answer is no. They must know that. And you mustn't be apologetic about it. You don't have to apologize to anyone to say, with my kids, the eerste antwoord, the standard antwoord is nee. And you must earn my yes. when it comes to my children. So with all that said, it is our responsibility as fathers to build our kingdoms so that history points to the power of our authority forever and ever. Amen.
Thank you so much, for bringing your father heart and just releasing. And pouring out your gift over us in a practical way. Thank you so much. Ladies and gentlemen, are you encouraged? Yeah, ladies and gentlemen, and I believe that this transformation that we keep on talking about is not just going to be a concept. I do believe this community will actually see transformation as a lived reality. Ladies and gentlemen, it is an absolute honor and privilege to introduce our next speaker. I would like us to take a moment and honor Mr. Mervyn Vermeulen. He actually flew all the way from Johannesburg with his family just so that he can come and join us today. So, Mr. Vermeulen, thank you so much for serving our communities. Thank you so much for the work that you are doing in the legal fraternity and for your movement. I think legal, where you are offering free, thank you so much, free access to legal information, and you are raising other attorneys and legal practitioners on family law, contract law, immigration. I just want to say thank you so much again for really coming here and sowing so freely and so generously to this movement. Let us give Mr. Vermeulen a hand of applause, please, as he talks about the.
All right, good morning, ladies and gentlemen. Thank you so much for having me here today. Colleagues, judge, members of the public, it's an absolute privilege to stand here in front of you today and to address you on a topic which I am very passionate about, and that is immigration and international relocation, specifically with minor children. Now, just in case, folks, you think I'm extremely generous to fly down from Joburg to Cape Town, Cape Town is absolutely beautiful, and I just needed an excuse. So thank you for the excuse, Dion. I really do appreciate it. Folks, my presentation today will serve as a bit of an introduction to some of the other presentations which you will be seeing today by esteemed colleagues of mine who are here on various specialized focused aspects. Hague Convention, Remo Acts, etc. Sorry, Natalie, I'll scooch down for you. Right. Okay, good. Okay, fantastic. Thank you. So my hope is to give you a bit of an overview as a starting point to better understand and have a foundational grasp of the concepts which our speakers later will be talking about. So, folks, I'd like to start off with a quote by Anthony Bourdain. If I'm an advocate for anything, it is to move. As far as you can, as much as you can, across the ocean or simply across the river. Walk in someone else's shoes or at least eat their food. It's a plus for everybody. Now, the reality is, folks, that South Africans are becoming increasingly globalized. South Africans are on the move. When you are in the south of London and you can order food in Afrikaans, you know South Africans are on the move. When you are anywhere in Europe and you see people speaking your language, talking about your interests, cricket, rugby, etc., you know South Africans are on the move. So what I've done as a bit of an intro is I've taken just a snapshot of a few recent headlines without saying that I agree with any of them as a big caveat. These are all headlines in the last year about South Africans abroad. And my favorite one is Checkers runs ads in UK, Australia to remind expats of better lifestyle in South Africa. And I'm sure we can all attest we are very, very spoiled in many respects, and we're very, very blessed to be where we are. However, it illustrates the point, folks, that South Africans are seeking opportunities abroad. What is I'd like to introduce with a new type of family unit to which the rules still apply, but they apply in a different way. And we'll go into that a little bit later. And in talking about the expat family unit, we must further distinguish between two types of expatriate family unit. And the first one I'd like to talk to you about is the concentrated expat family unit. You'll see from my clip art there, it is 2 parents, 2 children, and this is a concentrated unit, which we can define as follows. It refers to a family structure in which a small group of expats, typically consisting of parents and their dependent children, reside together in a foreign country for an extended period of time. The family unit lives in close proximity. This is the main overriding component of the expat or the concentrated expat family unit, is they are in close proximity, they share sources, and they rely on each other for support while living abroad. The term concentrated specifically emphasizes the close-knit nature of this family unit. They live abroad together, simply put. The second expat family unit, if I can, there we go, is the more unfortunate separated expat family unit. And in a previous sitting of this specific presentation, one of my attendees almost became distraught and made the point that where there is a separated expat family unit, there will always be a loser. There will always be a parent or a holder of parental responsibilities and rights, be it family member or a friend who has acquired. There will always be someone left outside alone. That is the reality of the separated expat family unit. So, the definition, which I've put in, those of you who have great reading glasses, please do read along on your printouts. I didn't realize my font was as small, so I apologize for that. A separated expat family unit refers to a family structure in which one or more parents who hold PR&R live separately from their minor children while residing abroad. Often occurs due to circumstances that require one parent to be in a different location than the rest of the family, such as work, divorce, visa concerns, etc. And here is the sad reality. In this family structure, the child is usually separated from one of the co-holders of parental responsibilities and rights. And obviously, this creates unique challenges in maintaining family relationships and ensuring that the child's needs are met. And as I will show you later, guardianship is of particular concern. So, as an expat family law 101 course, I would like to just go through a few legal principles. I will try to keep it short, succinct, because I know that a lot of these are aspects which you have dealt with at length, but for completeness sake, let's run through them. Obviously, where do we start when it comes to children? We start with the Children's Act, and when we go to the Children's Act, numbering always starts at 7. You start with the best interest of the child standard. I'm not going to go through the best interest of the child standard. But as we all know, in all matters where there is a child involved, best interests of the child are paramount. So everything that we will be discussing in respect of expat family units with children must be seen through the lens of the best interests of the child standard, which can be found in Section 7 of the Children's Act, and which I will not belabor. Now, where this becomes very relevant is I will be going through a couple of recent judgments, unreported judgments mostly, to show you how the courts have dealt with the issue of the best interest of the child standard in relation to international relocation. The second one, and it's an oft forgotten one, ladies and gentlemen, and I urge you to really take note of this next one, is Section 31.1. I'm going to go back to guardianship in a second. And Section 31.1 refers to major decisions concerning a child insofar as child participation is concerned. And as you will see under subsection B of the section, any matter listed in Section 18.3c, which is our guardianship issues, which we'll look at now, any matter affecting contact, and any matter which is likely to significantly change or to have an adverse effect on the child's living conditions, etc. In those instances, the minor child's views and wishes must be taken into consideration. And unfortunately, very often we see with these types of relocation matters that the child is nothing more than a passenger. In fact, the first thing the child knows is pack your bags, we are getting on the plane. Well, not quite as extreme, but a fait accompli is presented to the child. We are moving abroad. This is the way it is. Then I'd like to talk to you about Section 18 of the Children's Act, and specifically Section 18.3. We will be dealing with this a little bit in the case law, but 18.3c specifically, folks, take note of it. Consenting to the child's departure or removal from the Republic and consent to the child's application for a passport falls under our 18.3c factors. Now, what are those? Those are aspects where all holders of guardianship, i.e. both parents, must consent. You cannot simply remove a child from South Africa without the consent of both parents. You cannot simply apply for a passport without the consent of both parents. And if one looks at the word on the street, in some instances, even the consent is not enough. Very often, Home Affairs needs both parents to be present when the passport is applied for. The third provision that we are going to be looking at, and these, as I say, folks, just keep these as a foundational basis to understand the remainder of my talk today, is the issue of termination and suspension. It is unfortunately something that we see very frequently in expatriate expatriate matters, be it in divorce, be it in the context of post-divorce, be it in the context of unmarried persons. Very often, the one party's parental responsibilities and rights will be suspended or terminated, as I will show you in some of the judgments, which I will share with you a little bit later. Okay, so is everyone still with me? So far, so good. Got time? Great, I've got a few more minutes. Great. So these are the basics. In case you are concerned that I'm just going to tell you everything you know already, let's go to a little bit more obscure stuff. Let's go into the Immigration Act of 2002. And therein, under Section 9 sub 3A, lies our first problem when it comes to international relocation. No person can leave the Republic without a valid passport, obviously. Simple as that. Then we look at the South African Passports and Travel Documents Act of 1994, which gives the minister the power to make regulations in respect of how customs officials sitting at the various ports of entry will deal with persons going through customs at that stage. So what is the status quo with that? It is the following. Let's distinguish again between the concentrated and the separated expatriate family. The concentrated expatriate family is very, very simple. You need a copy of the birth certificate and you need a valid passport. Both parents are present. Obviously, your customs official will see that both of the parents are there. Both of their names will generally be in the passport. They cross-check it with the parent's passport. They give you the thumbs up and you go. It is highly unlikely in that scenario that one of the parents would be there with the child and not consent. So consent is fairly obvious. When we look at the separated expatriate family, however, it becomes a little bit more problematic. You'll see our list is significantly longer than the previous slide. Obviously, valid passport, as we learned earlier. Copy of the birth certificate, equivalent document, so far so good. And here comes some of the more contentious issues. The parental consent letter or affidavit in most cases, a copy of the passport or identity document of the absent parent, contact details of the absent parent, and where applicable, either a copy of the court order granting full PR&R in respect of the child to the traveling parent or a copy of the death certificate. The reason, obviously, folks, is Section 18.3c prevents parents from simply leaving the country without the consent of other holders of guardianship, and this is to give effect to it, specifically the requirement of the parental consent letter. Right. So, essentially, folks, immigration in practical terms can happen in one of two ways. The 18 years back, I'll give away my age, the first 18, not the recent one. They used to say we can do this the hard way or the easy way. And in immigration matters, it is specifically very, very pertinent, the difference between the two. Now, when you look at international relocation with a minor child, essentially these are the scenarios that are presented. The first scenario is abduction, and then obviously the Hague Convention comes into play, and I look forward to hearing my colleague Eugene Opperman speaking about that a little bit later. Then we get relocation by consent, which I've, for practical purposes, split into two specific sections, being informal and formal processes, and I'll take you through that a little bit later. And then finally, we get our opposed relocations, which end up running through the courts, where the court really has to deal with it. And specifically for now, at least, until the amendments to the Children's Act are come into working in terms of guardianship in the children's courts, these are high court applications. And we know high court applications really are often prohibitively expensive. So this is the informal structure of immigration by consent, ladies and gentlemen. So it is quite simple, very little red tape, very little planning, very little structure. Parent one goes to parent two, says, I want to relocate to location Z. Parent two says, no problem, signs the parental consent affidavit. The parties drive to Cape Town International Airport on the next Emirates flight out of here, gone. Right. Now, there are a few very problematic elements to that. Number one, there is no future planning. There is no provision for what will happen if things go wrong down the line. There is very high potential for co-parenting difficulties post-relocation, because what happens? You create an unequal relationship between the parents. The parent sitting overseas with the child has all the power. Parent sitting in South Africa has no power and no document to protect them. Usually in these cases, there's no or very little adherence to Section 31(1) child participation. The only benefit to this, obviously, is that there are very few formal steps required. Now, the bottom two are very interesting. There's no court intervention, obviously. In fact, the court does not know that this child is leaving the country because, quite frankly, no one has alerted the court. No one has issued court process. And further, the Family Advocate's Office also has no knowledge of this relocation, and they can obviously not intervene. Now, juxtaposed with the informal structure, we see a few extra steps, 4 steps, versus, if I can remember to count on a Saturday, 7 steps. This is the formal structure of a relocation. It's a bit more onerous, but I would dare say it is much more sensible. So once again, it starts with consent being sought, consent being granted. Thereafter, a parenting plan would be prepared. There would be a formal child participation in terms of the Children's Act, Section 31(1) and Section 10. And then the matter would go through the family advocate all the way to court. And I'll tell you why it goes to court generally in a little while, whereafter the departure from the Republic takes place. Now, the benefits are, obviously, in this instance, you have a document that regulates future planning. The potential for parenting difficulties are greatly ameliorated if you have a proper parenting plan. There is adherence to Section 31(1). There is court intervention. There is Family Advocate's Office intervention. But obviously, this comes at the price of several formal steps which are required. Just one caveat, folks, and it's not on my slide, but it is very important to understand. The minute the child leaves the Republic of South Africa, the South African courts and the South African legal system do not have jurisdiction over that child anymore. One notable exception is your Hague matters, where the central authority would intervene to get an abducted child back. So this is not a silver bullet. I'm not saying do this and you will be fine. This is certainly more sensible, but there are also practical limitations. And then we go into the final beast apart from our Hague matters, is the immigration without consent, which generally get battered out or battled out within the High Court. Step 1, always consent is sought. In this instance, consent is refused. Now, what most attorneys do in this instance is they would send a letter to the spouse not consenting or the party not consenting, or their attorneys, and say, we want an investigation to be done to see what is in the best interest of this child. Do you agree, yes or no? If they do not come back, very often, most cases, the matter is referred to the High Court on a Part A, Part B kind of structure. The first application, Part A, is for the appointment of an expert, formally by the court. It could be either through the family advocate, but in a lot of these instances, we do see private practice social workers, psychologists becoming involved. And the second part of the Part A deals with just the logistics of coming back. Part B is where the final order is sought for the court to allow the parent to relocate. After this part A, you have your child participation, you have family advocates involvement, and or social worker psychologists involvement, and there will be a report which is rendered indicating what is in the child's best interest. And in these instances, the court would then make an order dispensing with the consent of the non-consenting parent in terms of Section 18.5. As we all know, High Court is the upper guardian of minor children. It can override the guardianship of the parties. And then finally, departure from the Republic of South Africa. Now, there have been several notable judgments in this regard in the last year. I've veered away from reported cases, and I've elected to rather look at recent cases, even in the instance that they aren't reported, just to give you guys an idea of the zeitgeist that we are seeing in the courts. How are the courts dealing with it? Now, I have done summaries, but I have also given you the reference to these cases. All of them are freely available on SAFLI, and I encourage you, if you are working with someone in the process of immigration with a child, or if you're considering doing it yourself, please take the time to read these judgments. Secondly, please understand I do not work for JITA or LexisNexis. I'm not a professional person when it comes to summarizing court cases. So there may be one or two things in my summary which you don't agree with, and then please feel free to contact me and we can have a bit of a debate about it. But for present purposes, I think this will give you a bit of an idea. The first matter which I would like to look at, and here I'm definitely going to have to read here, hails all the way from the Johannesburg High Court, and this is F versus F. This was in 2022, judgment delivered on the 6th of April 2022 under the hand of Adams J. The applicant wants to take 2 daughters to the UK. There is already an order giving both parties full parental responsibilities and rights, obviously post-divorce. Respondent initially gave consent, but then withdrew consent. What are the legal principles? And this is where I want to really focus. Number one, the court found best interests of the child, or children in this case, are the first and paramount consideration. Now, what I find is interesting here is it's not only the paramount, but also the first. The court used it as a starting point, not as a lens, simply to see the other factors. Both parents have a joint primary responsibility, and then the question was asked, is the custodial parent's decision to immigrate bona fide and reasonable? And you'll see this as a trend. The court found it is, and the parent was given leave to relocate. Under the finding, folks, the second last bullet point, you'll see that the respondent's section 18.3C3 and 4 rights are terminated, not suspended, which I think is, under the circumstances, quite a harsh order against the respondent. But essentially what this means is the respondent's consent was no longer needed for application for a passport or departure from South Africa. All other parental responsibilities and rights are still extant and in existence. They are all subject to the court order made by the court. Contact is in place, care is in place, maintenance is obviously in place, and the other aspects of guardianship are still in existence. Right, so far so good? Yes. Great. I've got 15 minutes before Dion chases me off, so I better run. Next one we're going to look at is OM versus MC. Now, this is quite a recent one, excuse me. Once again, Johannesburg High Court. I indicated to you earlier I was very eager to come down to Cape Town. Everyone wants to bloom and leave Johannesburg. I wonder why. Anyway, so this was 3 March 2023, very recent, under F. Besaidenote AJ. Now, this was a very interesting matter. The issue of relocation was not a problem. The father conceded that the relocation would be in the best interest. What was argued over here was a reintegration therapy between the father and the daughter. The father made a couple of footfalls in the litigation, which came across very vexatiously to the court, consenting to something, withdrawing consent, consenting, withdrawing, and the court was quite displeased. Now, let's go to the findings in this matter. If I ever change here and I don't change there, please alert me. The court interpreted the questions of law with the best interests of the child as the overriding consideration as required by the Constitution and the Children's Act. And the court also made a comment that the High Court has wide powers to establish what is in the best interest of the child and is not limited only to the evidence presented by the parties, which I think is somewhat controversial. However, if one contextualizes it in bullet point 3, the judge had a chamber interview with the child. So the child was obviously able to express their desires, wishes, and their feelings to the judge. So in this case, the mom did manage to relocate with the child, and the logistical issues were sorted out. Why this is of relevance is it just gives us a good indication of a matter where the judge spoke to the child himself, as the judge is obviously entitled to do if one looks at the provisions of the Children's Act, and a very good section on it in Darfel and Skelton's commentary on the Children's Act in respect of that issue. Once again, just reiterates best interest of the child. As I say, when you're reading the Children's Act, you start counting from 7. Right, now let's have a look at the order. There would be counseling, there would be reintegration therapy, etc. I'm not going to belabor you by going through the whole thing. JB versus RE from your division per Village J, a very interesting judgment and a very interesting order, which I'd like to take you through. Once again, this is all available on SAFLI free of charge. The applicant wants to permanently relocate with a child to Lyon, France. Respondent refused to provide consent, refused that the minor child accompany the applicant on a holiday even to Lyon. The application was initially divided. Number 1 was for a holiday. Number 2 was then for an expert, etc. Now, there were 2 experts involved in this matter. Both experts recommended that the applicant be permitted to relocate. And in this instance, the court said, well, it is bona fide. The applicant has made out a case that it is that she has a bona fide reason for wanting to relocate. The experts were with her that it's in the best interest of the child. Now, what is very interesting in terms of JB versus RE is the safeguards that Judge Villa put in his order in respect of the minor child. So, point 1, the applicant was granted leave. Number 2, very nice protection for the respondent. Joint decisions about major issues concerning the child will be made by both parties. Once again, the execution of this in a foreign jurisdiction is problematic. We'll look at that in a bit, but a very nice safeguard that was put in. Here the court says even where the child will be going to school and who will assume responsibilities for the schooling costs. You can see all of these potential parts where there could be snags. The court closes off. Then the court goes so far as to say this is how residence will work. Airbnb first 3 months, then she's allowed to secure accommodation not more than 20 kilometers from the school. So the judge is saying, great, you can go, but I am holding you to this specific area so that you cannot take the child and disappear into the wild blue yonder. Then the interesting portion of it, I'm going to skip over a few of the issues, but X cannot be permanently removed from Lyon, France, not from France, from Lyon specifically, without prior written consent. And then obviously there is reference to the Hague Convention, as well as that there be a parenting coordinator appointed. So this is, in my view, a very thorough order in terms of practicalities post-relocation. Right, next one, 19 December 2022. We are back in Johannesburg because everyone wants to leave Johannesburg. 19 December 2022, under Mia J. Once again, desire to relocate, opposed. Child has indicated a desire to relocate. The family advocate recommended that there be a relocation. The first respondent purported to be concerned about the child's safety in Croatia. The court simply said that can be ameliorated by regular contact and option to return to RSA if necessary. And the court in this instance weighed up the relationship between the child and the applicant versus the child and the first respondent. So once again, best interest of the child are paramount. I'm sounding like a broken record, but I should sound like a broken record. Start reading from section 7. Best interest of the child are paramount. Then the court reiterates that each case must be decided on its own merit. When the interests of the child and an adult are not congruent, I love this, the adult's interests must yield to what promotes the child's best interest. Adults, suck it up, buttercup, do what's best for the child. Right, principle applicable to relocation, interests of the child are first and paramount consideration. And very interesting statement here. In most cases, if custodian parent wishes to emigrate, a court will not likely refuse leave for the children to be taken out of the country if the decision is shown to be bona fide and reasonable. At this point, I would like to point out to you, we've gone through 5 judgments and we have 5 out of 5 court permitted the relocation. So, what was the order? Once again, a very, very thorough order from Mia J, dealing with aspects of school, medical, passports, etc. Now, the interesting order here is 3 bullet points from the bottom. The applicant is to obtain a mirror order within Croatia within 3 months of relocation. Now, as I indicated to you earlier, folks, South African law is applicable within the borders of South Africa. How we get past this generally in international family law matters is you obtain a mirror order. And while I'll look at that fully a little bit later, essentially it means you go to the court in the host jurisdiction, in this case, Croatia, and you go to the court and say, look, this is the order I've got from a South African court. I want an order from this court on the same terms to make the South African order executable within Croatia. So respondent may do so if the applicant fails to do it. Obviously, a very, very important safeguard for the respondent. Right, then we are back in the beautiful Western Cape under the hand of Clutter J, 20 October 2022. Once again, relocation to UK. Father opposes, citing severance of his bond. The experts assessed and recommended continuing monitoring of father's alcohol dependency, etc. Now, here was something very interesting. There were 2 experts, Pettigrew and Campbell. Pettigrew recommended relocation. Campbell denied relocation or indicated that it would not be in the child's best interest. So here, obviously, the court had to really make a decision. And unlike the Solomon matters, there really is no way to cut the baby in half. You cannot substantially relocate. You cannot be substantially pregnant, as we all know. So the court had the unenviable task of making the decision in the face of competing expert reports. Now, the legal principles as applied by Clitter J here are quite interesting. The court must take an overall view to determine if the custodial parent's decision is reasonable. Once again, I've told you in the previous ones, this is quite a trend. The child's best interest, very interestingly, the court found is paramount, but are not absolute. I don't know if I agree with that statement. Nevertheless, it is an element of this judgment, and they must be considered in relation to other rights. Custodial parents' rights involve fundamental rights to dignity, privacy, freedom of movement. Limitations apply to the best interests injunction in consideration of other rights. Each case must be decided on its own merits. This case illustrates the balancing act, obviously, that the court has to fulfill in weighing up the rights of the parties and the child. Right, and Pettigrew won the day. The mother was granted leave to remove the child from South Africa to relocate to the United Kingdom. Right. So essentially, we went through 8 cases, all 8 cases recently. Relocation was permitted by the court. That is not to say that a court will just rubber stamp a relocation, folks. The reason for the relocation must be bona fide, and it must be in the best interests of the minor child. Do not try to relocate to a war zone, in other words. Challenges post-immigration. Let's look at those. As I alluded to earlier, and I'm going to use the 2 examples, Section 44 of the Children's Act, Section 62 of the Maintenance Act. If the child ain't here, the court ain't got power. That is a big problem that we are faced with, is the issue of jurisdiction of the courts once the child has been removed. Conflict of laws between countries is a massive problem. A good example is Australia. They simply refuse to give effect to a South African ANC. They take a look at it and they say, well, we're going to do what we want to do anyway, you know. So nothing we can do about that, unfortunately. So laws between countries vary. If they are inconsistent with one another, which system is to be preferred. Dion, have I got another 5 or 10? Okay, excellent. Not in trouble yet. Great. Practical difficulties, obviously. Contact, expense, time, location. Flight tickets are expensive. Visas are expensive. Major decisions in co-parenting. Remember, folks, we were talking about this unequal relationship that is created the minute the custodial parent leaves the borders of South Africa. The other parent is essentially beholden to what we can term the custodial or the relocating parent to find out what's going on in the child's life. There is an issue of distance. There is a potential issue of not being able to contact certain role players. In some instances, there is even a language barrier in respect of some countries. And then, obviously, guardianship, as I mentioned earlier, Section 18(3)(c), passports and leaving South Africa are problematic. Now, I've put a rider in there if SA citizenship is retained. If you are, as a child, not a South African citizen, Customs is going to give you one look and say, there you go, no problem. They simply are concerned with South African children in respect of the requirements to leave the Republic. So, as I indicated to you earlier, mirror orders can be obtained to give effect to orders in South Africa. So I've put in a little bit of a definition for you. You're welcome to read through that at your own leisure. Then, obviously, the renewal of passports and visits to South Africa, very problematic, 18(3)(c)(3) and 4. And that is where we look at subsection 5. Now, subsection 5 is generally the section in which the battle occurs in a contested relocation matter. And I say so because the court has, as upper guardian, the right and the responsibility to intervene in respect of guardianship issues. This section quite strangely worded in the negative, unless a competent court orders otherwise, consent is required. But essentially, I suppose it means the exact same as a court may intervene if one party does not consent. Right, then we look at section 28. Now, section 28 deals with termination and suspension of parental responsibilities and rights. I just want to once again reiterate that it is not a Boolean question. It's not a yes or no. Here, one can be substantially pregnant, as they say. You do not have to suspend or terminate all parental responsibilities and rights. You can terminate or suspend any or all. And what we very frequently see in these matters is that the staying behind parents, 183C3 and 4, would be suspended or terminated just to make administration issues a little bit easier. Then I'm just briefly going to allude to the Remo Act. I'm not going to go into detail with that. I really look forward to hearing Dion speak in respect to that. What I have given you folks, however, is just a list of all of the states that have acceded to that convention. And then obviously just the bare basics on Hague Convention matters. As I indicated earlier, I'm very eager to hear Eugene chat about this a little bit later. But just as a foundation, be aware of the functioning of central authorities in jurisdictions who work together or ostensibly are meant to work together to secure the return of children. In South Africa, folks, the Office of the Family Advocate is designated as our central authority, and I have given you an up-to-date list of all of these signatory countries. Now, I want to talk to mediators, attorneys, and members of the public in my last slide. Here are your tips when you deal with immigration matters. Please, as a starting point, research and understand the laws and the requirements of the destination country before mediating. I put on the slide, but before dealing with these matters. Understand that when the child arrives in the host country, they will be subject to the laws of that country. And it is in your best interest to understand those laws as a starting point. Number two, as I indicated earlier, children are not just passengers. They're not just along for the ride. Ensure that they're given an opportunity to participate in the mediation process. Anecdotally, some of you met my daughter yesterday, 5 going on 16, and she wanted to, with all her heart, relocate to Dublin in Ireland. And I said to her, my angel, why? She said, because they have a Disney shop there. Can't make this up. And when I pulsed her, and I said, but Opa and Oma are here, your friends are here. She said, oh yeah, that's true. And you could see the gears grinding with Disney shop on the one hand and family on the other hand, and it was a legitimate concern. But it just goes to show that children, even at that tender age, can think reasonably. They have the right to know what is lying ahead for them. Plan ahead to ensure all necessary arrangements are made before the immigration date. If you are not someone who specializes in expat work, I highly recommend speaking to someone who does. Generally, most attorneys are more than happy to share their information with colleagues and give guidance. Then consider the need for mirror orders, identify and include safeguards to protect the interests of all parties involved. Encourage open and honest communication between parties to promote understanding and trust. I want to just pause here to just remind you of the practical difficulties with immigration matters. The opportunities for conflict, very high. One cannot read tone or expression necessarily through a WhatsApp message or through an email. There is very, very high potential for lapses in communication, and it's therefore extremely important to encourage open communication, because the parties are going to have a devil of a time communicating across borders, no matter how amicable their split. Be respectful of cultural differences and ensure that all parties are aware of any potential challenges that may arise. Obviously, that relates to the host country as well as in South African context. Top priority, folks, broken record again, best interests of the child. I will pass on to Dion also to distribute to those of you who are interested, just a decision tree that I did a while back. And the first question you always ask, is it in the best interest of the child? If yes, proceed. If no, stop. Go back. Go to jail, go directly to jail. Don't pass. Begin, don't collect 200 Rand, go to jail. And finally, folks, consider the emotional impact of immigration on all parties involved and work to provide appropriate support and resources as needed. As I indicated to you earlier, Disney Shop is a very poor replacement for family, friends, culture, language, climate, understanding, feeling the land of your bones beneath your feet. So that was it for me, folks. I'm very humbled by the opportunity to have spoken to you. I really hope that I have given you some food for thought in terms of international relocation with minor children, and I hope it sets the stage for our esteemed speakers later today. Thank you very much for having me.
Thank you, Mervyn van Meulen. He is whom I call the family law giant in South Africa. Now to have to go lower because it's the shorter one. Mr. Mervyn van Meulen have a WhatsApp group called Think Legal. And there's a Think Legal family, there's a Think Legal contracts, and all those groups. I'm only on one of it. I can't afford to go on all of the other groups that Mr. van Meulen gives all his time. There's even a mediation group that my wife told me about. I really can't go on all of these groups. Mr. van Meulen, thank you so much for coming and flying all the way from Johannesburg to come over here on your own cost. Not charging and billing the NPA. I think it's still for free. I hope there's no invoice coming our way. We don't have the money. I'm telling now, it's going to go into the insolvency chain. It's not going to be paid by the NPA. So thank you so much for coming. Thank you. Thank you. Judge Daniel Tulari, my role model and the person that I've got the utmost of respect for. I've heard this talk of Judge Tulari in 2017 when Judge Tulari and I spoke in Ocean View. And I told my wife in 2017 already, you must hear Judge Tulari speak. And it took years to get you here. And that day I was touched. We spoke about the roles of fathers, and Judge Tulari just went up there with no documents, nothing, and he started speaking. And then I asked Judge Tulari in Bloemfontein if Judge can please come back and give that talk. This time there's a lot more substance, and I'm humbled by your just your words of encouragement and being so in touch with community, being so in touch with humanity. And that's what I sometimes feel is missing in our jurisprudence and the way our magistrates and judges deal with cases. So Judge Tulari, I am humbled by you and your presence being here. Thank you so much. Let me also tell you, in Bloemfontein, I heard another speech and I recorded it. I'm the only one that have a recording of it. And I played it to my wife. My wife and I listened to it a few times. Every time she needs to get encouraged to fight on, then she listens to that. And that's why I had to come and introduce you to her, because of how your speech in Bloemfontein touched us. And also the way you see certain things over there, and where you feel South African jurisprudence, South African family law should go in the next few years. And the other thing is, Judge Tulari was there first in the morning. And usually you'll see people will come late, or whenever it's their slot, they'll be there, and then they leave, and then they've got nothing to do with whatever's being done. Judge Tulari was there that morning first. Before I even arrived, Judge Tulari was already there. And the Sunday, when everybody else were already gone, Judge Tulari was still sitting and chatting to the clerks in a tent where we had our breakfast and things. Anneke was also over there, and Laurie, and we were still some of the last ones there. Luckily, I had a 12 o'clock flight back to Bloemfontein. Judge Tulari had the last flight 6 o'clock that evening that he only left. And if there's one person that have a sense of humility, then it's that man, that despite all that he achieved over the years, he will still be the last that leave the ship. That's the sign of a captain. A captain follow and lead the process. Captain shows with his leadership, I'm there first and I lead the process. I'm the one that leads and I will be the last one leaving. Judge Tulari left Mvelo Lodge in Bloemfontein last after he made sure all the other clerks were gone and everybody else were gone. Then he left. And that is the signs of our leadership today. We usually will just come and just do our bit, and then everything must be right and ready, and there must be water and stuff, and there they go. But Judge Tulari, thank you for your humility and leading the way for judges in South Africa. I know some of the cases that you're busy with. I am looking forward to one of your judgments that's going to lead the way for family law and fathers and the rights of children in one of the cases that you are busy with now. I am working with senior advocates at this office and thinking, how are we going to address you? So I am hoping to see how you're going to give judgment. I'm waiting for it. I'm going to come and sit in court because I know you're going to give some good jurisprudence and change family law for South Africans in such a beautiful way with your judgment that you're going to give in that matter. I do not want to speak too much about it. All of you have your package in front of you. You will see there's a barcode. Um, the old the eagles that have been over here every time, you will see that there is a barcode with the specific barcode that you, if you put your uh, smartphone towards the uh, uh, your page, then you'll be able to scan the whole presentation. So Mervyn van Meelen's presentation, you will be able to get a copy of it. The other documents that Mervyn van Meelen is talking about, he is giving it free of charge. Every week, Mr. van Meelen have these webinars that is free of charge, where he guide people and give this information to members of public as far as these type of cases are concerned. Natasha, can I get one, please? So please make sure that you get a copy of our handout. And on the handout, you will find, thank you, Natasha, on each of it, you will find a barcode. Just keep it there, scan it in, then you'll get the full presentation just the way it is supposed to be on that specific document. My presentation is already there, but I can't. Bongi, can you just get to my presentation? My password is dr@npa21. Now everybody knows it. So if you want to steal it, then quickly you can steal it. But if you just go out of that one, then you'll get to. Okay, but I will still continue. Dr. If you just go down, you'll find just go down. You'll find it somewhere there. But on page 28, you will find my presentation um, dealing with the remo legislation. And since my master and role models over here, let me also show him, otherwise is going to leave by tea time because of other commitments. Not that he wants to leave, but he has to leave. So I want to show him that at least he taught me something and I know something that I can impart on you. The first time I heard Judge Tulari speak about the remo legislation was in 2017 at a Justice College training that I attended. So all of what I'm saying now is actually Judge Tulari speaking over here again. I hope I can keep up to that level. So let me not be too what's the word I'm using? Proud, thinking that I will know everything the way Judge Tulari did it that day. But in your handout, page 28, those of you that have smartphones, just hold your smartphone towards that barcode, that QR code there. At the last page of each presentation, you also will find that even in your handout, if you keep your smartphone towards the QR code, you'll also be able to scan it. So don't think it's just there. If it doesn't work there, then just go onto your handout. You'll be able to do it. My presentation is on page 28 of the handout, and you will be able to then get a full color copy if you use your smartphone instead of this handout that is black and white, in case you would like to get a copy. My task today is to speak about the international legislation. I am not going to speak in detail about it. Mr. Eugene Opperman and I will be having a lunch and learn session on the international remo legislation pertaining to child maintenance, where we will go into more detail about deposition affidavits and all the things pertaining how the practical way that you should be making sure that you've got all your documentation in order. Mr. Opperman was busy with the divorce week, so we were quite busy myself, and that's why we couldn't get to do it. Donkey, you don't have to worry, I can change the slides myself over here. So we will make sure that we've got a full session, an hour session on the remo legislation pertaining to international maintenance whenever you have to deal with international maintenance. What you need to know whenever you are dealing with a case: the maintenance officer, as soon as you get to the maintenance court, they expect or they think that the mother coming there, the father is in the country. And what some of our maintenance officers do, and I'm sorry to say it, is as soon as they hear the person is in Malawi, then they say, no, we can't get him here. There's nothing we can do. And that is unfortunately not true. In terms of the remo legislation, there is ways that the Department of Justice can get hold of that person in the country wherever the person is. But in order to get there, the maintenance staff need to know what they are doing. Now, there is a document that the Department of Justice issued, which it's like a guiding tool. It's like a Bible for maintenance officers in how they should deal with these type of cases whenever these cases are in our court, international cases where the respondent is in a foreign country, or the other way around, where the respondent is in South Africa and the lady complaining is in one of the foreign countries. Now, there are two acts that specifically deal with it. There are two remo acts. The one is the old remo act on page 28, if you want to follow with me. On page 28 is first the remo act. Where am I now? Okay, but it is the 89 Act as well as the 1963 Act. Those are the two pieces of remo acts. The one is dealing with all the European countries, and then you get the Africa Act dealing with the 9 Africa countries that is listed as the countries that signed as a signatory to South Africa in that specific document. Now, I told you the Department of Justice officials have a document, a policy document that they are supposed to uh, consult whenever they are dealing with international maintenance matters. That is called the DOJ Code on Family Law 26 of 2015. In 2015, the Department of Justice and Justice Tulare was also involved, compiled this specific document to somehow guide maintenance officers and how they should be dealing with these type of cases. Unfortunately, if you're going to Google this specific document, you're not going to find it there. Unfortunately, policy documents you'll never find on Google or anywhere else. So the same in the NPA. The NPA has got a policy document. Part 26 of our policy document deals with maintenance matters. So those are the policy considerations that the people working in the field of maintenance need to look at. First of all, the Department of Justice's maintenance officers, they will look at DOJ Code 26 of 2015. The prosecutors acting as a maintenance officer in terms of Section 4.1 of the Maintenance Act, they will look at the policy consideration in Part 26 of the NPA policy. So those are the policy considerations that they need to look at, and that's like their Bible whenever they deal with these type of cases. Now, the DOJ Code 26 of 2015, page 40 to page 51, deals with how they should do it, where they start, what is the documents that need to be done, the deposition affidavit in terms of Section 8 of the REMO Act. All of those things are explained step by step on page 40 to page 51 of the Department of Justice's Family Code 26 of 2015. That's where you'll find all of those details pertaining to those type of cases. Unfortunately, the DOJ Code is first all the information, and then towards the end, you get all the documentation. Now, I'm talking about the different forms, Annexure V, Annexure W, Annexure Y, all of those documents you find on page 119 to page 123 of the DOJ Code 26 of 2015. So you first need to read the first 11 pages, page 40 to 51, to see what is the steps that the clerks, the maintenance officer must follow. And then you get the forms, what forms should be used, page 119 to page 123 of the document whenever maintenance officers deal with it. Unfortunately, the Department of Justice, the NPA's policy document, Part 26, dealing with maintenance, and now prosecutors deal with it, do not have a word about international maintenance. And unfortunately, my colleagues run away when it comes to international maintenance. But it's time that we keep the prosecutors liable for it, because they need to know that. Because in terms of Section 4.1 of the Maintenance Act, a prosecutor is deemed a maintenance officer. Therefore, in the absence of a maintenance officer, that prosecutor is deemed a maintenance officer. So he can't run away and say, nee, fok, ek weet nie wat die gaan nou nie, or whatever, because that's what they quickly do. There was a case, Anna Mutimunye, and Judge Tulare will be able to give you even more insight into that case. Ms. Mutimunye went to a court in Gauteng, and when she got to the court, she was looking for a maintenance officer to help her with a pension fund, to get a pension fund. There was no maintenance officer there. There was only a prosecutor. Prosecutor just looked at it, pension, no, I don't deal with pension, and therefore I'm running away. But the prosecutor forget that in terms of Section 4.1, they are a maintenance officer. They cannot run away. Even though the policy document, Part 26 of our policy document, say prosecutors stay away from civil. Part C of our policy document, C7 of our policy document, Part 26 says that prosecutors do not get involved in civil matters unless it's relevant or unless it's needed in terms of the Act. Meaning, in terms of Section 40, when there's a conviction and then we want to attach and we want to use the attachment procedures, then we use Section 40. That's where we get involved in. Else, the Section 26 to Section 30, we do not touch on it. And that's what happened in Anna Mutimunye's case. Ms. Mutimunye came and said that, listen, my husband ran away. He's not paying his maintenance anymore. There's a pension fund here. Please help me to get the pension fund. Prosecutor at the court where Ms. Mutimunye went to said, no, there's no maintenance officer come. The maintenance officer might be over here on Thursday or Friday. Then you will be able to get a maintenance officer. Prosecutors are not going and cannot run away, even though international maintenance is not covered in Part 26 of the NPA policy. A prosecutor is deemed a maintenance officer. So whoever is going to be a DOJ maintenance officer in terms of Section 4.2 of the Maintenance Act, or a public prosecutor in terms of Section 4.1 of the Maintenance Act, both of them are maintenance officers. Under no circumstances should we let a person walk away from a court without getting the necessary help that they're supposed to get from the maintenance system. The DOJ Code 26 of 2015, right in the beginning on page 13 of the DOJ Code, it's a lot of pages to read, but I know the thing. I've been working with it for almost 8 years now with my colleagues in the middle. Mr. Cato Jackson, can you quickly stand? This is one of our senior maintenance investigators in Wynberg. That's Mr. Cato Jackson, a colleague of mine, and he is the one that deals with all the cases in the southern suburbs. Mr. Cato Jackson. Next to him is Mr. Clive Peterson. Mr. Clive Peterson, can you please stand? That is my retired maintenance colleague and trusted person, my left and right hand. He helped me a lot with our cases in Belleville to get all our Belleville cases sorted out. So I just want to somehow acknowledge my colleagues sitting over there and their impact in my life and making sure that justice is being done for our children. Okay, let's get back to the REMO Act. So you have got the DOJ Code 26 of 2015, page 4251, that says how maintenance officers should deal with international maintenance matters. I found on the Facebook groups that some maintenance officer says, no, they don't deal with it. You must go and get an attorney. That's nonsense. Maintenance officers are trained in order to deal with these type of cases. Judge Tulari been training them since I don't know when, but Judge Tulari can vouch that these officers are supposed to assist whenever we are dealing with these cases. 40 to 51, 11 pages where we guide them on what to do, how to compile the deposition affidavits, how to compile the bundles, and 4 sets of bundles, where it should go. All of that is indicated in page 40 to 51 of the DOJ Code 26 of 2015, page 119 to page 123 of the DOJ Code deals specifically with the forms. What are those forms that needs to then accompany the deposition affidavit that goes in with it? So if you want to, please read to page 28 to 31 of my slides in the handout. There you'll get all the information pertaining to it. So your point of entry whenever you deal with it on page 41 of the DOJ Code says that the clerk or the maintenance officer need to know whether there is a treaty or if the country where the respondent is, if there is a treaty or an agreement between the countries to work together. Now, these agreements and the way they work together, all of them had to sign as signatories to the REMO legislation. On page 12 of Mervyn from Helen's handout, if you turn to page 12, there you will see the list of countries that are involved in the REMO legislation. It's a little bit faint, but just do that what I told you in the beginning. Just hold your smartphone there, then you'll get a whole copy of it, because you're going to struggle to read the handout because it's in black and white. But be it as it may, those are the countries that are listed. You'll find it's less than 40 countries that are listed in terms of the REMO legislation, in terms of the old act. In terms of the 1989 Act, Act 6 of 1989, there's 9 African countries that are listed in terms of the Africa Act, the REMO Act pertaining to the African countries. What we in the NPA, whenever we do training with public prosecutors, to tell them is, in the absence where that country is not listed in your REMO legislation or in the Africa Act, then you look at other international treaties. My wife will also touch on it, as well as Eugene will be touching on it in their presentations. But the most important that you need to know is, if the country is not listed in the REMO legislation, on page 12 of the handout, if that country's name is not appearing there, and it doesn't appear in the Africa Act or 6 of 1989, if it doesn't appear in any of those, then we can also look at other international treaties. The other international treaties include the UN Convention on the Rights of the Child. Page 31 of my handout, if you look at page 31, then you'll see Article 26 and 27 of the Act says specifically that you can then look at the UN Convention on the Rights of the Child. The nice thing about the UN Convention on the Rights of the Child, there is 196 countries listed. America is unfortunately not there, I don't know why, but some of the countries in the United States, outside of the United States, are listed. Canada is there and other countries. But look at the UN Convention on the Rights of the Child. Most of the countries, there's a lucky chance that of the 196 countries listed in terms of the UN Convention on the Rights of the Child, subscribe to Article 26 and 27 dealing with maintenance. So in the alternate, if the REMO legislation is not applicable, or if you can't use it because the country is not listed, then you use the UN Convention on the Rights of the Child, Article 26 and Article 27. My wife will also be talking about it in her presentation, but those are the countries that have a treaty. In Bloemfontein, Judge Tulari, we spoke about the High Convention on the International Recovery in Child Support and Family Maintenance Matters, that we should look at that specific UN treaty and maybe consider using the UN Convention on the Rights of the Child, the High Convention on International Recovery in Child Support as an alternate. Unfortunately, South Africa is not a listed country and is not a signatory to that treaty. So therefore, we cannot use the international recovery method that is being mentioned in the Hague Convention on International Recovery. It's only 45 countries that are listed, so we can try, and our DG, Doc Mashibani, said that we will see if we can get our name next to the line and sign it with the other 45 countries. Then we might have 46 countries. That is in terms of the international recovery in child maintenance. Hopefully, we will get that piece of legislation up and running soon. Then we will be able to get these international recovery done. So what's your first point of entry? A deposition affidavit must be completed in terms of Section 8 of the REMO Act 80 of 1963. In terms of that piece of legislation, you need to have a deposition affidavit. The lady is going to complete a deposition affidavit in which she says, I know dear narrators, I've got a child with him, that we have so many children, here are the birth certificates, here's the ID documents, we got divorced, and here's the divorce settlement. All of those things will be covered in it. Index page will be completed with the deposition affidavit and all the documentation that is needed in order to get the person liable on the other side. The most important thing that you need to know, and it is in the DOJ Code 26 of 2015, you need to have a recent photo of the respondent in the country, or a most recent photo of the respondent wherever he is. What's the reasoning behind it? Once all the documentation is completed over here in the court, then it goes to Pretoria to a unit called the Department of International Legal Relations. From there, it goes to another unit called DIRCO, and DIRCO will then take that, it's Department of International Relations and Cooperation in Legal Matters. From DIRCO, it goes to the embassy or the consulate in the country wherever he's finding himself. From the consulate, it will go to the county wherever that person is living, and then the sheriff of that county will go and serve the documents on him. Now, if I'm living in Malawi and my ex-girlfriend is looking for me, the snake that Judge Tulari spoke about, is looking for the snake and can't find the snake, then how do you get hold of him? That is the reason why that photo is so important. You need to have a recent photo where they can see that it is him. If you have a beard, try and get one without a beard so that they know, because the narrators can stand in front of the sheriff in the county and say, is this you? And said, yeah, Kenny, I don't know who it is. Then it's the same person saying, so it must be a recent photo. Don't look for a photo that was taken in 1971. It doesn't look the same anymore. So make sure it's a photo that is most recent so that the sheriff in the county where it is will be able to find him. So what is the documentation? A deposition affidavit, ID documents. If he was paying while he was in Malawi or he was in Canada or wherever he was, Ontario, or wherever he found himself, and he already paid into a Western Union account or whatever, and you can show the money that went in and out, then that is the way that they will be able to maybe find him in case they have a system in place in the other country wherever he is. So a deposition affidavit, ID documents, bank statements, all of those. If there are communication between you and between the dog and the snake, and you've been sending emails, waar is of wanneer betaal jy die geld in? All of those have to be translated into the language, into the international language. You cannot say in Afrikaans stuff, ek soek die geld vandag. They don't know what it is. Make sure that it is properly done so that the judge that's going to sit in the reciprocating country will be able to understand what is being said. Also, if you can convert it to the most recent amount, because they don't understand what's rands and cents and all of it. Australia don't even look at it. Those people don't know what they're doing. They're still wearing loins and walking with the lions. They don't know. So therefore, they discard it. Make it easier for the person in the other country, because when that document, the court order that was made by the court over here, get to that side, they don't want to struggle with it, because the court on the other side can only do a few things. Can confirm the order, can amend the order, don't have to make any order, or can send it back to the country and say, I don't know what this random sense is, I don't understand these Afrikaans messages translated, and get a translator to certify that it is translated. All of those things, they don't think twice to send it back. That process takes nothing less between 6 to 8 months from the country where it starts, the originator from where it starts. I've seen cases in Belleville Court that started in Belleville Court that I'm still busy with. I'm a Mackenzie friend. I don't know Mackenzie, he's not my friend, but I'm a Mackenzie friend now. Because in the UK court, I had to assist a lady, and this lady wanted to be part of the process in the reciprocating country. Unfortunately, South African, the attorneys that are over here, we do not have any legal standing. They call it right of audience, not right of appearance, right of audience in the reciprocating country. So Mr. Mervyn Vermeulen, even though he's our giant, will not be able to stand in that court unless he has a right of audience in the UK courts. I'm diminished from an advocate to a Mackenzie friend. I don't know Mackenzie, but he's my friend now, just so that I can be in a court and be able to assist a lady with the process of what's happening and explaining certain things that these judges are and the people are speaking in court, that she said, I have absolutely no idea what they're speaking, but it's my children. I need to be able to understand it. The UK Legal Aid Act in 2012 was abolished as far as legal aid is concerned. They have to deal with it themselves. So that is the predicament that some of our mothers might find when it goes to the UK or any of the other courts. So what I recommend is, whenever you deal in the Western Cape with any case, there are 10 senior maintenance prosecutors in the Department of Justice's National Prosecuting Authority, the NPA, dealing with these cases. In the Western Cape, it's Advocate Dion Reuters dealing with it. You see him, he's the person that can deal with it. There are 38 cases in the Western Cape that are REMO matters at this moment in time that I deal with. If there's any of those cases, let me know beforehand and let me get involved right from the beginning and then deal with it. You do not need a legal attorney, a private practicing attorney, because the legal aid is not even going to say, we don't deal with that stuff. They don't want to hear about it. So in any of those cases, whenever it's got to deal with a REMO legislation, let the senior prosecutor in that province know about it. The online people in all provinces, there are are a senior maintenance prosecutor that is supposed to deal with international legislation, including AEMO. We've got the statistics that we submit every month. In it, we need to say how many AEMO cases are in your province. That's why I can say for certain there are 38 registered cases in our 57 courts in the Western Cape. There are 453 maintenance courts in South Africa, and all of those courts have a provincial senior maintenance prosecutor. The Eastern Cape has got 2, KwaZulu-Natal's got 2, all the other provinces has got 1 senior maintenance prosecutor that need to report to our national office pertaining to international maintenance. So make sure, if you know that he's in Malawi or wherever he is in Windhoek or he's in overseas, get hold or tell the lady that's coming for mediation or the lady that's coming to you or to your advice office or the online viewers that are listening, if you have a respondent in the other country, get hold or find out who's the senior maintenance prosecutor in that province that deals with these type of matters in order then to make sure that you get that order being done. Okay, so deposition affidavit, bank statements, photos, a recent photo of the respondent, all of those documentation will be four-folded. There must be 4 copies being made by the court, and that will go to the reciprocating country. There's other procedures in page 48 to 49 dealing with certification. There's a specific way that these international countries want things to be certified. We're not going to come and say the way we certified the police justice stamp and all of it. There is a specific wording, Remo Act 80 of 1963. This is a exact photo, the replicate of this document. Each and all of those documents should then be properly certified. If it is not properly certified, the lady is going to have a problem on the other side, and the child is going to suffer if it's not done properly. So that's the reason why I'm saying make sure the senior maintenance prosecutor in your specific province know about your case and is involved in that case, because they need to make sure checks and balances is being dealt with and it's made sure that that thing is done properly. 4 sets of copies go to the Department of International Relations in Pretoria. There's a lady over there. She's going to kill me. Her name is Mary Wilson. She deals with these type of cases, and she makes sure all of it is done properly. And from there, it will go to the DIRCO, and from DIRCO, it will go to the other country. On the Department of Justice's website, you will find a brochure. In that brochure, it explains the 4 copies and what must go with that specific document to the other country. Once it leaves South African shores or borders, then unfortunately there's nothing that can be done from there onwards unless you get an active lady that wants to be part of it, like the case that I'm involved with in the UK now, that wanted from the beginning to get something because you want to know what's going on. Why is it taking so long? Where is my case? And that's how I managed to make friends. I didn't want to be Mackenzie's friend, but I became his friend. And then in the process, I made friends with the crown prince and all the people in the UK dealing with these cases and what must be done and step by step how it is being done in the UK. But if you don't get an active senior maintenance prosecutor that guides your case, it's going to take 6 to 8 to 12 months before it gets there. And then if there's something wrong and it's not confirmed or it is amended, it's going to take the same time back to the other country. I dealt with a case in Kuilsriver that I had to go to Windhoek, and Windhoek is not far from here. I can tell you today a donkey cart could get there faster than what the Remo process could get there. And if somebody's not going to take note of that case, then that donkey cart is going to be in Van Heinsdorp and not out of Western Cape yet, in order to make sure that that order is being confirmed in the other country. So what I'm saying is, when we deal with Remo, please listen to Eugene Opperman and I. We will deal with it in Lunch and Learn. where we will go into the intricacies of how your deposition affidavit should be completed and how that form should be certified, because that's the most important part of how you deal with these cases. The reversal process, the applicant is is in the foreign country and it needs to be done, and the respondent is over here. The most important thing is, as soon as the case is coming from the foreign country, it need to be registered in South Africa as a 1431 case, in terms of our maintenance registration dealing with those cases. And then the respondent must be called to court as soon as possible in order to start that process of confirmation, amendment, or deciding what to do with those cases. I found some cases in the province that have been on the court for more than 2 years. You cannot let a child wait for 2 years. I always make the example, and my colleagues up there will attest to it. Jesus couldn't survive 40 days in the wilderness, in desert, without food. So if a human being that is so pure and without sin can't survive 40 days, how do you think a mere mortal child will be able to survive 6 to 8 months for it to go to that foreign country and then 6 to 8 months come back to this country? Anna Mutimunye says that we need to deal with this with urgency. If we're not going to deal with this with urgency, then we are failing our children. The Maintenance Amendment Act, in Section 10(6) of the Maintenance Amendment Act that came in operation on 9 September 2015, says that maintenance officers must make sure that these cases are being dealt with as soon as possible and limit the postponements and the duration of these cases. We cannot have a case on the court for months and months and months without there being at least an interim order that is confirmed in Section 10(6). There are hundreds of cases in the Western Cape where there is not even an interim order in place. And and that's why we have these community dialogues where we educate the public online and the ones that are willing to offer their Saturday in the cold and rain to come and listen to us, so that we educate them that this is what you must do. You must ask for your 10(6) order and make sure that you get that. Mr. Eugene Opperman started a WhatsApp group. There are 300 women in that group, and some of them are online that will attest to it. They ask these questions. 10(6) says I must get my interim order. Why is there not an interim order? Now the maintenance officer, no, you're too clever. You mustn't come here. I know that is happening, but there is a way that we deal with that. The Magistrates Commission have a place where if a magistrate is rude to you, we deal with them. In the Western Cape, if a prosecutor is rude to you, go to cclark@npa.gov and report that prosecutor that is rude to you. If a maintenance officer in the Department of Justice do not do their work and don't deal with your case, the DOJ Code 26 of 2015 says there will be disciplinary procedures, but they've never been. But we need to, at each and every court, there's the information board. On that information board is the name of the court manager, the area court manager, the director court operation, the regional head. All their names are up there. So the online people and the people that are over here, take a picture of that the first day you get to court, because that's your first point of complaints. If they don't listen to you, then you go to the Magistrates Commission and tell the Magistrates Commission, these people don't want to help me. The magistrates are not making Section 10(6) interim orders. We need to hold them accountable. If we're not going to hold them accountable, we're going to be sitting and complaining. That's why you get Facebook groups with 55,000 and 80,000 people, because people are complaining, and that's where it stops. If we complain, we must complain to the right people. If the Department of Justice's regional office don't listen to us, then we go higher. Then we go to Mr. Malema and Doc Mashibane and all the people. Not EFF Malema. There's other Mr. Malema. Sorry, Julius, it's not Julius Malema. There's other Malema. But you can also go to EFF. EFF like taking these type of things on. So make sure that you complain to the right people. If the provincial people don't listen to you, you go to regional. Doc Mashibane is the Director General for Justice. We complain there. If the Magistrates Commission don't listen to us and update the Magistrates Commission website with Mr. Dawood still being the Secretary General, even though he's not there anymore, then we tell Parliament's Justice Committee that, listen, these people are not updating, so where must we complain? If we're not going to take the lead and complain, then all of us are going to be sitting and just increasing the Facebook group from 50 to 60 to 80,000. And we will just have these WhatsApp groups with 300 women and just complain. In the WhatsApp group, I always ask the ladies, okay, stop these emojis. The emojis is not going to help you. Say what you want to do and where are we going next? Have you complained to the regional head? Have you complained to the provincial head? If you didn't, then forget your emojis. I'm not interested. Somebody needs to take charge of your case. Section 28 of the Constitution says that children have a right to have a legal representative of their case there. In most cases, you don't find legal representation, unfortunately. But that doesn't, and the mother that's going to go and stand in court can't even get Section 11(1) subsistence and travel allowance. They struggle to get that. I want you to listen to Dr. Carmel van die Kerk when she speaks about her challenges. A doctor struggling in the maintenance system in order to get justice for her children that is legally qualified and have all of that knowledge, and still she struggled in the maintenance courts. There's a case involving other people higher in rank and senior people that are also struggling the same way. The only way we're going to change that is being part of that process of complaining and giving our inputs in it, like Dr. Carmel van die Kerk will be doing later. The DOJ or the Law Commission issued a paper 157, on the maintenance amendment, where we can participate and say how we want to change the act. And I want to encourage all of you over here to please participate. There was a few of us, Mr. Opperman, my wife, and some of the people are now sitting there at the back, and some of the people, Ms. Carnier also, that commented on it. Paper 157 is up for review. That is going to change the Maintenance Act. And if we're not going to now make those type of comments and say where we want to change it, Section 10(6) says there must be an interim order. I didn't get an interim. I never even knew about an interim order. All of these things we need to highlight. Now, us will be discussing Section 11(1), subsistence and travel allowance. When we go to the courts, the mother, when she goes and applies, then the magistrate says, no, but you're applying, then why do you want now taxi fare? Why must we give you taxi fare? You applied for it. No mother goes to court because she wants to be there. Was 'n lekker dag vandag, ek gaan by die hof gaan sit. I want to see the mother that ever wanted to go to a court because she loves being at the court, or she wants to get the latest, oh, Bongi is sitting there, I wonder why she's there. There's no human being that wants to be at a court. So why are the Department of Justice's maintenance officers and the court manager and area court manager withholding a Section 11 subsistence and travel allowance to just help it? It's because baby daddy don't want to pay his maintenance. That's why she's there. And to withhold Section 11(1) subsistence and travel allowance because Regulation 5 only speaks about a respondent and not about an applicant is unfair towards that mother. But when that happens, the mother says, okay, then it's Sycamore, all right. There's nothing else I can do, because they see the maintenance officer as the point of superiority that they have to believe in. That's not the end. What I'm telling the online people and the delegates sitting over here is, if you ever have any problems, first thing is you take a snapshot of that board, that information board, and from there onwards, hold them accountable for what they want to do. Remo legislation, there's no need to get an attorney because the attorneys don't know how to deal with the Remo. Sorry, Mr. Opperman, Mr. Vermeulen, and the other attorneys sitting here. But I've seen in cases that I've dealt with, that my colleagues over there at the back have to guide the attorneys in how to deal with these things because they have no idea how to deal with email. But they will go along with the process because it is legal fees that is going to 150 to 200,000 that I've seen people pay. So what I'm saying is, our email legislation, you don't need an attorney to help you. The maintenance officers is supposed to help you. Page 40 to page 51 of the DOJ code on their policy documents say they must help you. If you want to have a copy of it, the DOJ code on page 1 says there must be a copy in their library. So while you're sitting at the court waiting for your name to be called, tell them, let me go to the library. I want to sit and read your DOJ code. Then you acquaint yourself with the DOJ code. Page 40 to 51 is all you need to read, and page 119 to 123. If you know those pages, take your smartphone and take pictures, and then afterwards, my book, Eddie, yellow DOJ code, can sell it out there and make money out of it. But make sure that you have got the whole code to be able to deal with you and to assist you with that. But if any of you have any problems with it, please speak to the senior maintenance prosecutor in the Western Cape. That's me, DRators at NPA. On the last page of your handout, page 31, my email address and my office number is over there. If you have a case, please let me know, and I will start monitoring that case until that order is confirmed in the reciprocating country. Judge Lai, is there anything that you'd like to add pertaining to? Are you okay? Okay, thank you. I must have done a good job then if Judge Lai is not adding any. In Bloemfontein, I just had to sit and listen in awe how Judge Tulare over those 2 days tried to guide us. So if there are any questions, then please ask those questions on email. There won't be time today because we've got such a big program and so many speakers that still need to speak. So you can still see me afterwards if there are any pertinent questions that you'd like to ask pertaining to international maintenance. And as I say, lunch and learn, we will deal with the IMO legislation over the next few days or within the next month. Mr. Opperman and I will set up a specific document or a specific video and all the different deposition affidavits and all the forms pertaining to IMO will then be included in that specific lunch and learn session that we will be conducting. Thank you so much for listening to me.
Thank you so much, Advocate Emeritus, for that informative session. Ladies and gentlemen, we're going to take a 30-minute break and we will be back at 12:15. See you back at 12:15. Thank you. Someone left their car key in the bathroom. us on our social media pages, Facebook and Instagram, and today right, ladies and gentlemen, we still have quite a few speakers to go. So, yeah. Once again, thank you so much for joining us for the show. We are focusing on international child maintenance. And I am so pleased to introduce our next speaker, Dr. Kamal Kamika. She is a senior lecturer at the University of Western Cape College, and she recently submitted an article on the daily market struggle for child maintenance in the lower course. What a single parent should do. Today, she's just going to come and share her insights and her observations of her experience as a single mother trying to navigate the maintenance system in South Africa. Ladies and gentlemen, let's give her a warm hand of applause, please.
Afternoon, everyone.
Good afternoon.
Thank you so much for having me, and thank you for providing me with the opportunity to share my very traumatic experience in trying to get maintenance for my minor children. Okay, so from the title of my presentation, Failing Our Children, a single parent's perspective on the current child maintenance system. Just by the title, you can see or hear our distribution. 3 law degrees has not helped me at all. It didn't help me at all in trying to get maintenance for my twins. It has been a long journey, and regrettably, my kids didn't get out what they are entitled to. So it's very sad for me, but I'll tell you about that a little more shortly. So who am I? I am a single parent. Yes, I am a lecturer at the University of the Western Cape. Ironically, I teach family law and advanced family law. Yeah, it's been really cruel to me in that respect, because I'm trying to teach people about the law that I'm suddenly finding myself questioning after my personal experience. So that's what I do. I also specialize in reproductive law, but my entire journey has made me question everything that I do, because reproductive law is about creating families, and you ask yourself, do you want to assist people in creating families if the end result is as catastrophic as mine was? You know, should I not just be encouraging everybody to snip? Is that what the way forward? You know? Well, at least men, maybe, you know, do us that favor, snip. Okay, so this is basically both a personal account and partly reflections of what I've learned in my professional career. So yeah, that's where I'm from. Okay, so let me give you a background to my story. What I call, the first part is called the honeymoon. I didn't name it that. A psychologist actually said that's what we call it. So my former husband walked out in November 2020. Yeah, he was just done one morning. Okay. And so we separated, and when he moved out, he made a number of promises. The first promise he made was regarding childcare, because we had a nanny. And he promised her that nothing would change. I want you to look after the twins until they are finished with school. Okay. He made that promise on more than one occasion. I was not involved in that promise at all. I didn't ask him to make that promise. That was something that he made without my knowledge, and she somehow or later told me about. Then there was the child maintenance promise, and that was made in January 2021, where he promised to pay a certain amount of maintenance, which was actually less than 50% of the twins' needs. Okay? Didn't want to be greedy. Because, you know, you women get this perception. We want all of their money. That's all we want. Anyway, that's what happened. He made a lot of other promises. You keep the house. I want the girls to have stability. You can imagine the house became an issue. Yeah. So I will help you transition to this new period. I will provide financial support to get you into the position where you can cope with just your salary. It went really well for a couple of months. I got maintenance up until August, but then the honeymoon ended. It's very sad, as honeymoons always do. In my case, I got an email. He made the unilateral decision that he was no longer going to pay maintenance. You can just apparently do that. Just drop an email. I'm done. So I was like, okay. Then he paid maintenance. And then in September on the 21st, I got another email. At the end of September, I will not be paying the maintenance. You can liaise with my lawyer or with your lawyer and further with my lawyer. October 2021, I got no maintenance. Apparently you can do that. So let me briefly talk about a child's right to maintenance, which you all should be familiar with. Natalie, can you? Oh. Oh, am I doing that? Sorry. Okay, so you should all know this, that it's based on what a child's reasonable needs are, okay? And here, the standard apply is keeping the child's standard of living consistent with what the child knew before, as far as reasonably possible, right? And it's a pro rata calculation. The perception is always 50-50 because they contributed 50% of the genetic material. The assumption is that is how much they must provide in maintenance. It's not actually like that, okay? But everybody assumes wrongly that it is. So it is determined with reference to what the parties earn, okay? So what did that include? Housing, clothing, food, medical care, education, and other necessary needs, whether it's childcare, etc. What are the requirements? There are 3. It's the fact that there must exist a duty of support. These children, support them. Secondly, the person must need maintenance. They're minor children. That bit is obvious. And he can afford the maintenance claim. Tick, tick, tick. Okay? I ticked all the boxes. But still, none of that mattered. So on the 13th of October, 2021, off I went to Bellville, magistrate's office. Okay. I submitted a very lengthy application. You know, doing my PhD did not prepare me for those forms. And my PhD is almost 200 pages, but I'm just saying, did not prepare me for what I had to deal with at the maintenance office. I was so overwhelmed. I can't remember how many times I had to phone the maintenance office. Have you guys served him yet? No, we can't serve him. He's out of the country. We must wait. Okay. Then after a million emails, he decided that he was going to pay something. Something was a paltry amount, and it was 20% of what I previously received. I won't tell you what my bond is in the area that I live in, but somehow on my junior lecturer salary, I had to keep keeping a roof over the twins' heads. I had to buy a new car because he took the family vehicle. I had to provide fuel, food. I'm sure none of this is new to you. It was terrible. Unfortunately, I don't have parents. They both passed on. So it was just me. And I had to keep going. No family support. It is what it is. Made me a lot stronger, but it was a very unpleasant experience. Eventually, so I was getting this 20% from November. And then because they couldn't serve him, I'm like, what must I do? Because that is not going anywhere. Am I supposed to just keep on waiting What am I waiting for? I'm not very good at waiting, by the way. Okay. So my attorney said to me, well, the other option is a Rule 58 application for interim maintenance. And I'm like, how much is it going to cost me? Initially, 50,000. Okay, 50,000. It eventually cost me closer to 70,000. Then I had to bring that application, but I'll get to the Rule 58 now. But then when he was served with having to appear into the maintenance for the inquiry, what he said was the first time he didn't bring his documents. I'm not allowed to disclose my pay slips. It's a breach of confidentiality with my employer. My employer, my international employer, does not allow it. Now, I don't know how I'm supposed to get to this international employer, okay, to verify this, etc. So at the second maintenance office inquiry, he brought an attorney, and I was served with a notice of bar. You can't bring an application for maintenance in the maintenance office if you are currently bringing an application in the magistrate's court for a Rule 58. But neither of these processes were moving fast. And in the meantime, I have payments that are due. Okay. So there, the maintenance officer I could see she felt frustrated. She didn't know what to do. This man is literally obstructing every attempt to pay maintenance. The things that he said about how much he spends on himself is ridiculous in comparison to what he was willing to spend on his children. Can I just tell you, he earns double what I earn, tax-free, in dollars. But yet, there's this assumption that I had to keep providing and he could do what he wanted. Then, Rule 58, go to court. The magistrate is pressuring us. I put it in quotes, but you know what? You guys must try and settle this. But nobody asked me, is this a person that I can enter into a reasonable settlement agreement with? Nobody. There was just this constant pressure, you need to settle. I understand that magistrates are overwhelmed. I know what court rolls look like, but there was, and eventually we reached a settlement where I ended up with 2/3 of the amount that he had initially agreed to in the honeymoon period. 2/3. So if I just think of all the percentages, 20%, 2/3, I still had to keep a roof over the twins' heads. I still had to make a car payment. I still had to keep providing them with everything that they needed on my lesser salary. Anyway, so that was the mediation process. That order kicked in on the 1st of June. Like I said, it cost me 70,000. Don't ask what my current financial status is, but you can well imagine. Then the magistrate referred the matter for mediation because we can't settle. I can understand. You guys are right-thinking individuals. You should be able to reach a settlement. The two issues that we couldn't agree on was the patrimonial consequences and child maintenance. But interestingly enough, the patrimonial consequences were less contentious because of the antenuptial contract. So the biggest issue was actually child maintenance. At no point did I ask for spousal maintenance because I worked. I've always worked. I don't need a man to support me. But for goodness sake, support your children. They didn't ask to be here. They didn't ask for you to walk out. They didn't ask for you to work abroad. You chose that for yourself. They didn't have any choice in any of this. So why should they suffer? The fact that you are out of the country half of the year, why should they give up the home that they have, which is their stability,
so that you can have a good life. Even the twin psychologist said their home is a point of stability. I do not recommend that we change that because their dad is not a permanent fixture in their life. So they need something that is familiar. Okay? So even if they go visit their dad when he is in the country, they still have somewhere that they can hold on to. It's a lot of pressure for one person to keep a bond of over 10,000 every month alone. And contrary to popular belief, UWC doesn't pay that much. Just putting it out there. Okay. Okay, so we went to mediation, and that was from May to July. It cost each of us approximately 20,000. Yes, no, we didn't know about you at that point. But the point is, we went through all of that. The mediator calculated that based on his income and based on my income, that he should be contributing 62% towards the twins' expenses. And me, 38. So you can imagine, look at the math, it's almost like 2/3 him, 1/3 me, but I've been doing more than 50% for a while. And that 50% takes a toll, okay? So what I liked about the mediator is that in the approach that she adopted, there was regard for what is in the children's best interest. That was clearly considered, and he just refused to budge because he put my children in a box, the 10,000 box. I will not pay more than 10,000 for these two children combined. The 10,000 box. So because I knew he wasn't going to budge, I eventually had to accept 50-50. That was my compromise. That would have given me close to what he had initially agreed upon, and it would have given me enough. Not everything that I needed. It would make scraping by a bit easier. So there we agreed on an amount. It was a reduced cash amount by quite a lot. But anyway, I was willing to do that. 3 days after we reached the agreement, before the mediator could type anything up, he reneged. Welcome to my life. Every agreement that I've ever reached with this man was reneged. Anyway, so we had to go back to court. Our first court date was in January this year. Okay. So the matter was 1 day of trial was allocated. Any attorney will tell you that's not even nearly enough for such a contentious matter. So we did part heard, and then the second dates that we could get was only on the 12th and 13th of July to accommodate the magistrate and when he was back in the country. Coincidentally, I was supposed to attend a family law conference in Belgium that week. Abstract was accepted and everything. But then when I heard those were the only dates available, I pulled my application because I just wanted this matter to end. So there I lost another growth opportunity that will ultimately benefit my children, but this was more important. The week before, I was attending a summer school in the Netherlands, work. And I got an offer from his attorney. What he's currently paying is what he's offering, but now it must include high school fees for the twins. So what I've been getting for the past year, now it must include extras. So that amount must go even further. Have you guys seen what high school costs? I mean, and I'm not even talking private school. It's more than double what I currently pay for primary school. Anyway, so that's me. So I said to my attorney, I'm sorry, this offer is ridiculous. How does this man expect his children to live? She's like, you can't reject it. You can't just say no. Don't forget, the magistrate has indicated that she will make a costs order against any party that is unwilling to engage in settlement. But I mean, how can you accept 10,000, which must include high school fees? How the heck does 10,000 include high school fees? Then what are my children eating? What roof must be over their heads? It's ridiculous. How must I get them to school? Anyway, so I came back from the Netherlands and I was like, okay, you need to come up with a counter offer. So what did I do? I resorted to the agreement that we reached in mediation. I said, that's my offer. That is what I was willing to accept a year ago. It's not what my children are entitled to, but I will take that just to bring an end to this. So I sent that and I said, I want 50% medical and actually put a child on your medical aid. It would make things so much easier than constantly having to ask you for refunds every time there's an expense, because the medical aid was depleted in March this year, people. And I'm on a top plan. Usually we last till June, but this year we didn't make it. We were done by the end of March. The twins have developed extra conditions that need medical aid or medication that is not covered by, chronic benefits. And we currently spend 3,600 Rand on the twins' meds for the month. But I must still give 50%. Friends have asked me now, where your salary then was finished 3 days after payday. It's called my credit card. My children need medication. What must I do? I need to put in fuel. What must I do? That is the sad reality. Anyway, so we were back in court. And then he came back with, no, I won't pay childcare. I'm like, okay, what is your alternative? My 80-year-old mother will look after the twins when you have to travel for work. I don't know how practically this was going to work. So I said, that is not a feasible option. Anyway, so it was back and forth. I got the offer at 8 o'clock the night on the 11th of July, the night before we were supposed to be in court. I also got a call that morning. Can we postpone the matter by 1 day to attempt settlement? I said no. We've had more than enough time. And if I forfeit one trial day to this and it fails, how long must I wait to get more days? So we eventually reached settlement, but again, I had to reduce my cash offer. My kids are now getting 3/5 of what they are legally entitled to. So I had to let go of 2/5 of the cash component. Not that I decided, an independent mediator who I've never met before mediation. So you can imagine I was quite disillusioned because I felt like I'm being forced to settle on something that I felt I shouldn't have to compromise on. It wasn't about me. This isn't about spousal maintenance. This is about child maintenance. Why must single parents even be put in this position? So, what are my reflections on this process? You can imagine I'm disillusioned. In the maintenance office, the maintenance officer tried to act in my children's best interest. But the attempts of him and his legal team to block their right to maintenance, and I can't tell you, there was more back and forth that I haven't shared. Because later on in this matter, they wanted the magistrate to separate maintenance and the patrimonial consequences so that he could get the accrual that he's entitled to, but then I would have to go back to the maintenance court to fight for my children. And the magistrate eventually said, but hang on, you barred her from going there. This matter could have been resolved. The maintenance could have been resolved a long time ago. Anyway, but best interest was not even considered because the maintenance officer wasn't given an opportunity to get there. Okay. In the Rule 58, because there was pressure to settle, again, nobody asked me, nobody asked, is this settlement in the children's best interest? There is an assumption that parents will act in their children's best interest, but the reality is that this is not really the case. And when a single parent tries to fight, she's being unreasonable, she's greedy, she's whatever. But nobody sees what the cost is of raising those children, the day-to-day running costs. Anyway, then in the divorce trial again, there was pressure to settle. My children's best interests were once again overlooked. Nobody asked, is this agreement in the children's best interest? So the conclusion that I've reached is that the legal system, as I experienced it, have failed not the single parent, but failed the children. I haven't even brought myself into this equation. And I know that I'm not the only single parent who has to go through this. I've met so many women just sitting outside court, that row, you know, oh no, he didn't pitch again. I'm like, no, that story. Because apparently we don't have fathers, we have a whole lot of sperm donors walking around, which is more up my alley, you know, sperm donors, etc., reproductive law. Anyway, in my experience, the mediator was the most concerned, which is kind of sad. Why did the mediator have the most vested interest in what was in my children's best interest? I was paying her. Why was she that person? But you know what drove her is her reputation. In the sense that she wants to be the person that is known for being equitable and fair. It's not just the money. It was about, what does that say about her as a person? And I must commend her for her role. It's just sad that, you know, the kids didn't get out what they want. And maybe mediation needs to be considered earlier in these processes, but preferably not at 20,000 per person. Okay, so what is the international component? By now you can tell that my children's father works abroad. He works on a rotation, so he's only here half the year. The international factor was really challenging because when he says, I can't disclose my payslips, what could we do about that? We just had access to his bank accounts. But for all we know is his employer was siphoning money somewhere else on his instruction. How must I know? SARS, don't let me forget what my obligations are, because my payslip reflects everything. There is no extra income, you know? So he could hide his income. He could hide his payslips. Still haven't seen it. But I know for a fact my children are getting less than what they are entitled to. His rotations also played a role because that impacted on when we could get court dates, everything had to be juggled around when he was in the country. My life has been on hold for 2 years and 8 months. So the international component definitely makes things harder when the co-parent is abroad, okay? What are my regrets? My regrets are that I didn't have to sacrifice my children's interests. I wish I didn't have to do that. I wish that litigation wasn't so expensive. I mean, I'm sure you can. I mean, if I think about what I've spent and what I could have done with that money, my roof is currently leaking in 6 places. The same roof I'm going to keep over my kids' heads, but yeah. I wish that there was a better system in place that didn't pit the interests of the parties against each other and had better regard for the children. Maybe the children need to come with their own attorney. You know, make this because I was fighting for them, but I got tired. I got so tired. Never mind the fact that the twins were dealing with their own trauma from the divorce. One moved into my bed for a whole year. Every movement wakes me. The other one calls in the night, so I have to go lie by her until she falls asleep. When their dad is out of the country, it's a little bit more better because they're not going anywhere. You know what I mean? But every time we go through this, my sleep is disturbed. I am exhausted, which you can probably tell. You know, makeup can only do so much for you. I wish there was greater protection for the primary caregiver. And I'm saying the primary caregiver, I'm not saying the single mother. Yes, it is predominantly the single mother, but my parents were divorced and my dad was the primary caregiver. So I'm saying for the primary caregiver, the person that needs to incur the most expenses, and also for the children. This lengthy periods without adequate maintenance. I mean, I thought about the international situation and the donkey car, and I'm like, you know what? I don't have patience for things that must take 8 months, because how do you even? But even this was terrible. For 8 months, I got 20% maintenance from what he initially agreed. I got battle fatigue. I wish that that could have been avoided because it's tiring. I don't mind sacrificing myself. That's what parents do. But sacrificing your kids, they deserve so much better. And then I wish that I had gotten area maintenance. The system screwed me, it screwed my children, and I didn't even enjoy it. Sorry, was I not allowed to say that? Well, that's me, I'm just saying. And I wish that there was greater liability for the defaulting parent. I wish I could tell you litigation is over. It's not. My divorce was finalized on the 12th of July, but guess what? My nanny hasn't received a bonus from him in 2 years. And I said to her, can we just wait? I don't have the energy to fight on more than one front now. Can we just finish the divorce? Then I will pull myself towards myself and we will fight for you. And he just refuses to pay. She's looked after our children. She recently got swine flu. The kids came back from a camp with swine flu, and I was away for work. And when I got home, I had to wear a mask, but all 3 of them were sick. My nanny was so sick, she couldn't come out of her room for 3 days. This is the person that you won't pay. I paid my half with the less that I have. I don't owe her anything. I should probably mention he refused to maintain the dog as well, but you know, it's okay. Let's just focus on the children. Poor Max has been deserted. He doesn't get any maintenance. I just thought, you know what, Max, it's okay. We can't fight for all of you. You're going to take one for the team. So Max now no longer gets dog food contributions anymore. The dog that he brought, and which I said, you are going to have, now I didn't say no, I knew it was good for the kids, but I did say, subject to the condition that you would take responsibility for this because I am carrying too much already. At that point, he wasn't working abroad, but he was working shifts, which meant most of it was on me. And we didn't have a nanny at that point. So that was the agreement I made. But, you know, he's very good at reneging on agreements, as you can tell. So poor Max doesn't get any maintenance. Anybody? He eats Montego? Just saying. Because he's not as young as he used to be. But heaven forbid I give the dog away, because then I'm accused of psychological abuse. That is one of the things he accused me of. When I said I can't afford to feed the dog because you're not paying maintenance, he accused me of psychologically abusing the children. Yes. How must the dog eat if the children can't eat? Anyway, so I'm going to have to go back to court for the housekeeper nanny's bonus for the past 2 years, and it isn't even that much. Sad. I currently, because he refuses to pay her salary initially because I am benefiting from her more. But here's the reality. I pay half her salary. I provide her with a roof over her head. I provide her with food, electricity. So I'm giving for what I'm benefiting, but it doesn't matter. So I've not had the best experience. But where does that leave me? I don't believe in just complaining. What is the solution? Now, please, those of you that are maintenance officers, maybe just close your ears for this part. I think we must take the system away from where it currently is and give it to SARS. Why do I say that? This is by no means a new suggestion. It has been made by academics in the past, based on the New Zealand system. Inland revenue collects child maintenance. The applicant submits with all of those documents. I'm not saying we should fire maintenance officers. They might just move to the SARS office. Okay? There's still going to be an inquiry, but there's going to be a more objective criteria where there's a calculation of what every child's minimum should be. You know, basic needs. And then you factor in mom's salary, dad's salary, and then you work out how because I mean, if SARS can figure out what we must pay without any involvement with us, I'm sure they can do that for our children. And once a decision is made, you can appeal, like SARS allows you to do. People can intimidate maintenance officers like I discovered, but who's going to intimidate SARS? Nobody. So that to me would be, I think, the better solution. I don't know how SARS feels about that, but to me, it seems like the most practicable solution to a problem that is just not getting better. People should not have to rely on Social Security. In my case, my children's father is more than capable financially of providing for them. And that is the reality in so many cases. It's not that they are unemployed, because you know what? If you are unemployed and you can't provide, SARS does factor that in, doesn't it? You don't pay tax. So if you're earning less than a certain amount, allowances and adjustments are made. But I'm saying our kids need more. Whether a child is planned or a surprise, you know, I had both. The second one was a surprise. I tell her that often. We didn't plan you. But the point is, they didn't ask to be there. And I really think that we need to be doing more for our children, especially when it comes to child maintenance. We owe it to them. And that's me. Thank you. I didn't even get to the benefits, but okay, you'll forgive me. No.
Sure. That is heartbreaking. Dr. Faneker's story is almost every mother's or single mother's story. Our kids need more. The system is not working. So where to from here? Where to from here, ladies and gentlemen? Is there a better solution? Because our kids can't wait for years for basics. But somehow, as mothers, we are expected to just make this work. South Africa, we can do better than this. It is an honor to introduce our next speaker for today, Ms. Natalie Reuters. Again, I just want to say thank you so much for your heart for restorative justice and just how you just carry a heart for our children, your passion for helping parents here in South Africa and overseas in navigating the complexities of co-parenting. Ladies and gentlemen, let's give it a warm hand of applause, please.
Okay, good morning, good afternoon, everyone. It's lovely to be here, and we've had some amazing speakers this morning. I see Judge Solari has gone. I feel very honored to have heard him speak this morning. I know I heard his speech 5 years ago when Dion told me about his talk, and when Dion convinced him to come and share with us, I said, please could you ask him to do the speech that he did 5 years ago? And I think he really encapsulated what my heart is. I always say that we are parents to community, not just our own biological children. And so when we work in these spaces as a mediator, as an attorney, as a social worker, as when we're working with families, let's be cognizant of the fact that these children are our children too. The spirit of Ubuntu. And yeah, thank you, Mervyn, for gracing us with your presence. I learned a lot of law from you. I always say to Dion that you and Eugene, I understand you guys better. You're not trying to give me an LLB in 1 week, but rather you really teach the law in a way that I can understand, because law is too complicated for me. So thank you for gracing us with your presence. Thank you, Nadia, for accompanying him. And she's not here. Oh. Well, thank you for borrowing Mervyn to us. We really appreciate it for the 2nd year in a row. Yeah. And Dr. Kamal Van Niekerk, thank you so much for being very vulnerable in your story, for sharing. And I read your article that was published in the Daily Maverick a while ago. So for those of you who haven't read it and would love to read the article, please do ask myself or Dion, and we'll share the article with you. Also very vulnerable. And I think for me, it is frightening that someone with a PhD and so affluent with the law is still struggling with her own children and maintenance. I am so grateful that Mervyn and Dion kind of covered half of my presentation. So I think I'll just get to the story part. But I think, like Bongi said, last month at the last dialogue, we had the voice of the father. And it was a dialogue that I was deeply impacted by and forever changed. Lots was said and lots was shared. And again, I was changed by that dialogue. I spoke on parenting plans and co-parenting. So I wanted to sort of do a recap on that, but I think Mervyn has covered a lot of the sections that I wanted to refer to. These sections, or these acts, in my opinion, are the cornerstone for any mediator, social worker, or attorney that is putting a parenting plan in place or a maintenance plan in place. Be mindful of these acts. Always have them at the back of your mind, understand them, and know what is permitted and not permitted. So I'm not going to go through all of it. It's all on the slides. From the Section 28 of the Constitution is, for me, the underpinning act that I like to work with. It talks about the rights of the child, and we build on that. Then we have the Children's Act, and Mervyn covered a lot of those sections, so I'm not going to go into them. It's Section 18, Section 31, Section 7, Section 9, Section 33, and Section 34 of the Children's Act. And more importantly, above all of that, as a mediator, I like to insist that the voice of the child is heard. That for me is probably the most important thing, is to hear the voice of the child. And so when parents want to do a parenting plan, so they're still in South Africa and they want a parenting plan, the first thing I insist is the voice of the child, and even more important when a parent is relocating with or without the child. Really important to get the voice of the child, like Mervyn has pointed out. Over and above that, I think it's important that we understand the international instruments that Mervyn and Dion has covered, and I know Eugene's going to cover a few of those international instruments. But for me as a mediator, the three that I try to rely on or understand when I am working with parenting plans and maintenance plans is the UN Convention on the Rights of the Child, as well as, and reflect on Article 26 and 27 of the UN Convention on the Rights of the Child. Article 26 speaks on social security for the children, and Article 27 speaks on maintenance and financial support of the children. I also reflect on the Hague Conventions on the International Recovery of the Child Support and the REMO Act, which Dion has spoken about. And I think more importantly so is, like Mervyn said, we must always make sure that we understand the law in the other country where the child will be residing, or the non-custodial parent, so that there can be a mirror order once an order has been made locally in South Africa. And as mediators, when we're preparing for mediation, there are some things that we must take into account. And so some of those things are time zones. So be mindful of the time zone when you are the mediator and you're trying to conduct a mediation cross borders. Be mindful of the schedule of the other parent as well as your schedule. You don't want someone waking up in the middle of the night, coming into a mediation, and they're not fully applying their mind to the session. So time zones are really important. Time zones are also important when you're talking about contact for the children. So call contact with the children, be mindful of those time zones. Be mindful of the currency of the country where either of the parents would live, either the non-custodian or the custodian parent, and mindful of the cost of living for where the child will be residing when doing a maintenance plan. Also be mindful of the culture of the country where the non-custodian parent or the custodian parent will be living. And I'll show an example of a story that will highlight some of these things that I'm talking about. And more and above all of that, it is important that as a mediator, find an attorney that is an expert in international law. Let them help you guide the process and also help you type out that deed of settlement, parenting plans, and just make sure that it's complying with the other law in the other country. But what I really want to share today is that mediation can be unique to the solutions, can be a unique solution to the circumstances that present. And I listened to the talk that Judge Talari did in Bloemfontein. And one of the things that he said was that he really believes that family matters should be settled outside of the court. And I think for those of you that know me, I'm all about stories, and so I'm going to share a story with you. It is an example of a case that I mediated. This case was in South Korea. So again, like I told you, let's be mindful of time zones. They were 7 hours ahead of me. So when I planned the consultation, I had to be aware of the time that I would conduct the mediation, and if both parties were in a state of mind to be able to participate in the mediation. So I started my mediation at 8 o'clock South African time, and they were 3 o'clock South Korean time. I also understood why we were mediating. And so I knew a maintenance plan would have to be put into place. And the first thing that I did was research the currency and understand what the exchange rate was to that, and get an idea for the living expenses in South Korea. And what happened was, and also understand the culture. So I don't know if most of you know, but in South Korea, when a woman falls pregnant, often she loses her job. You become unemployed when you fall pregnant. So she lost her job. And then what happened was, because she lost her job, she is South African. She was referred to me by her therapist. And she's lost her job. She's South African. She doesn't have family in South Korea. So there was no support financially for her. There was nowhere for her to go. And he didn't want the child. And he had valid reasons for why he didn't want the child. And I think this is what's important about mediation, is that everybody brings their fears, their concerns, their wants, and their needs to the table. And all of them are validated. There is no right or wrong in how anyone is feeling. We went into the mediation. I heard everyone's fears, the mom's fears. Where is she going to go? What's going to happen to her? She's got no family. If she comes back to South Africa, there's no medical aid. She loses her medical aid that side. She's 6 months pregnant. By the time she comes to South Africa, it's too late to get onto medical aid. Take all of that into consideration. And the nice thing about mediation is, as we talk and we listen deeply to one another, often the parties find the solution for themselves. And Dr. Van Niekerk said that the mediator decided an amount for her children. It should never be that. It's the parties involved that come up with a solution to why they are mediating. And as we were in the session and we were talking and they were sharing deeply about their fears and their concerns, they came to an agreement. And for me, their agreement proved that mediation can surpass all legalese that domestic violence and international legislation cannot do. Now, I know that's a very controversial statement, but I think if you have parties who agree to something, and not everybody can go into an agreement, and not everybody can participate in a mediation. But I often say that the agreement is enforceable by the parties themselves. And this agreement that the couple came to, in my opinion, the rights of the unborn child was taken into account. Now, I know in South Africa, our Maintenance Act doesn't make provision for an unborn child. And in my discussion with Dion, I found out that there's a term for this, emigrates fiction, which means unless the child is born alive, the mother cannot claim maintenance. And so this agreement that the parties came to was against what we know in the Maintenance Act, against the emigrates fiction, and also against the lane-in expenses. So we know in South Africa, you can only claim lane-in expenses as noted in our Maintenance Act after the child is born. I also found that because there's no treaty between South Korea and South Africa, we couldn't really mirror the order here or in South Korea. But the story is far more complex. So the origin of the father is not South Korea. And we know that this contract can be mirrored in his country of origin. So that was our saving grace. And I just want to share a bit of the contract. So the contract the parties entered into was that he accepted paternity, and this is a big thing, is that the deed of settlement worded the contract so well that the question of paternity cannot be questioned later in future. He also offered an amount of maintenance towards the child from the day the child is born. So the mother is reassured that once a child is born, there will be maintenance for her child. He also agreed to buy her an air ticket back to South Africa so she could be with family and she can be looked after and supported by family, taking into account that she's got no money now while she's unemployed. He also offered and realized that her medical aid will be cut off once she leaves South Korea, but when she comes to South Africa, it would be too late to then apply and get onto medical aid. So he's going to cover the birth of the baby in a private hospital. He also, or they both realized that she needs to be buying baby blankets and clothes and bottles and that kind of thing for the baby. So he's agreed to an amount that he would pay the mom and she'll start buying the things for the baby. So when the baby's born, there is stuff for the baby and not wait for the line-in expenses that mothers often have to claim 3 months or 6 months after the baby's born. He also then offered, and he realized, you've got a bit of debt here. And we know that if you want to come back one day to work in South Korea, if the debt is still in your name, chances are you might not get your job back. So in good faith, I'm going to cover your debt. And the way we worded the contract as well was, he also knew that she would like to go back to South Korea to continue her career once the baby is born. So we had to take into account that the living expenses in South Korea are far more expensive than living in South Africa. So we looked at like creche fees. The creche fees in South Africa are not as expensive as South Korea. And we worded it in such a way that when the mother does move to South Korea, they will mediate the maintenance again to fit the living expenses of the child in South Korea then. If the mother does not go back to South Korea, we have built in an increase, an annual increase. And I think what I really want to stress here is, initially, the father did not want mediation. He was against it. I invited him to mediation 3 times. And then it was 2 weeks, he was dead silence. And then he contacted me and he says, I'm ready to mediate now. And once we had the mediation, they came to this agreement. And for me as a mediator, what I want to point out is there's no law in South Africa, in our maintenance system, in our Children's Act, that speaks about the rights of the unborn child. But here, the rights of the unborn child in a space of mediation was recognized and upheld. The rights of the mother, and recognizing that she's lost her job and that she doesn't have financial support, was recognized in the space of mediation. And so was the father's rights. All his concerns as to why he didn't want to be a father were valid. But between the two of them, in conversation, they came up to an agreement that upheld each and every one of them, all their rights, the unborn baby, the mother, and the father. And so I want to be as bold as to say that for mothers in South Africa, when you fall pregnant and there is dispute around the way forward, maybe mediation can be one of those things. a space that you can talk and secure the future of your unborn child. I'm going to leave the challenge there. I think that's all that I'm going to say for today. But over and above that, one of our ambassadors, Faldila, she's still here? There she is. One of our ambassadors, Fadila, she's been here from day one, and she's really got the heart of an activist. She's forever in community. I just wanted to take this time and wish her happy birthday. Happy birthday, Faldila. Thank you for all that you do for us. We're going to sing for her. Happy birthday to you. Happy birthday to you. Happy birthday, dear Fadila. Happy birthday to you. Thank you.
Wow, thank you so much, Ms. Natalie Reiters, for that educational talk. And I'm going to introduce our next speaker for today. He is a regular at our NPA Soccer Community Dialogues, Mr. Eugene Opperman. Here to talk about, he's going to address us on the UN international instruments, in particular into the area of child abductions. Thank you very much.
Right, thanks, guys. Sorry, you just caught me with some snacks outside. Just to echo what Natalie said, with taking cognizance of international dealings, taking cognizance of the time. I did a very successful child abduction case of people in Japan. I never realized, while using the interpreter in South Africa, using myself here, and then speaking to the people in Japan, in Tokyo, that there was a 7-hour delay in time. So you would have some serious Chinaman sitting at the other side trying to understand via the interpreter and myself with a time difference. And I never realized that there was a 7-hour time difference, but it does happen. Right, so what we will be discussing today is child abduction in terms of, Dion's not necessary, that's fine, of child abduction that is governed by the Hague Convention. Now, South Africa, we work with laws. Like Judge Chirari also said, we work with acts, we work with bills, we work with international treaties and stuff like that. Our constitution makes provision that we could use international treaties as law. We could also use customary law in South Africa, and we may use foreign law. So where does treaties or bilateral intercontinental relationships and treaties fall in? Most definitely, it could be used in a court of law, and that is the Hague Convention is a typical example of something that could be used as an international instrument that could be used in South Africa. Now, the Hague Convention deals mostly with child abduction. Now, there's a common misperception in South Africa that we have, especially when it comes to children's rights, and we talk about and we think about kidnapping and stuff like that. And this is not a talk about kidnapping at all, or treading on thin grounds of human trafficking and so forth. But some stats actually tells us, and that's South African stats, that 45% of people being kidnapped in South Africa are children, which is horrific. And despite all the talk about children's safety, every 5 minutes, or every 5 hours, a child goes missing in South Africa. That is just in South Africa. That's just to give you some context of how big the problem of children going missing. Could be via kidnapping, it could be abduction as well. It happens in South Africa. It happens quite frequently in South Africa. So people see kidnapping and abduction as interlinked, and it's not. Kidnapping is totally different than abduction. Now, kidnapping, all kidnappings start with abduction, but not all abductions are kidnapping. Kidnapping is derived from the word kid and nap, to snatch a child, whereas abduction means to lead a child away. Now, if one looks at that type of definition and we bring it into South African realm and the legislation, it means abduction, as we see it, is by leading a child away, would in effect mean that you would have some kind of relationship with that child to lead them away. It's not kidnapped. There's a big difference, legally speaking, between kidnapping and abduction. Obviously, kidnapping involves where a person is unlawful transported or confined in a certain sense, and it's usually done for ransom or some illegal purposes, and it does carry more severe sentences. It is a very severe sentence criminally in South Africa if you are getting charged and found guilty of kidnapping. Whereas in terms of abduction, it usually refers to the illegal taking away of a person. It could be by force, but it could also be by way of deception. Come with me. Nie van hier so vir jou stokkie lekker nie. Not like that. It is coming with me. We're going on a holiday. We're going on a holiday overseas. Parents split up. One stays abroad. They live in Spain. Come with me for the holiday, and then never to be returned. That is what we're talking about, abduction. And that differs vastly from the term kidnapping. Abduction can also occur in child custody cases and legal proceedings, and we see that quite often. Where do we see abduction cases become so prevalent? Just after a December holiday. That's our field season for attorneys dealing with specifically Hague Conventions matters. People go overseas for the Christmas holidays with a one spouse or with a one parent, and the parent keeps them there and not to be returned to South Africa. And then you as the parent sit in South Africa wanting your child to come back because they need to attend school. They've got their dog that needs to be attended to, eating Wantigo, and the child's not coming back. So what do you do as a parent? What do you do as a parent? Calm down to a steady panic and then use the legal instruments that are available. Obviously, there are less severe penalties when it comes to abduction because there's no criminality. There is a portion of criminality, but it is not to such an extent that kidnapping might be. Right, so the Hague Convention, when do we use the Hague Convention? Like I said, the Hague Convention is an international convention. It was signed by a number of signatories, countries, that said, you know what, we sit around a table, we sing Kumbaya, and we decide that we are going to tackle this problem that we have. And this is the problem is that children get removed from one country to another. So we all come to an agreement to say there should be a structure in place or a system in place where we get those people back to the parents in the other country. So at this stage, there's about 103 countries that signed the Hague Convention, dealing specifically with the return of children that has been abducted. I personally don't like the word abducted, but there is no other word to be used. So the Hague Convention is an international organization or agreement between 100 countries. It aims to prevent international child abduction where one parent has wrongfully removed or detained or retained their child in another country. It aims to return the children to the country where they are classed to be habitually resident. And I'll explain the habitual residency later on because that is also a very contentious subject. It is believed that the courts in the country where they are habitually resident are better equipped to deal with these type of matters. So South Africa signed the Hague Convention on the 1st of October in 1997. Obviously, like I said, the purpose was of all these countries to bind and to make an agreement with each other to say, but you know what, if we have these type of situations, we would assist. You can rely on us if the person is a signatory or in a country, for example, Tokyo or in Japan, and if they are a signatory to the Hague Convention, then that country of origin, that country, Japan, would assist in bringing that child back to South Africa. That is what the Hague Convention is used for. Most of the EU countries signed the treaty or the convention, so as most of the Commonwealth countries and very little of the African countries. Strangely also that most of the Muslim countries, the Emirates, have not signed it. Try getting an order from the Emirates. It is close by impossible. They just send you a letter, hankak. It's just like, don't. They just don't adhere to it. They don't give a damn about South African law. I had a problem with Spain as well, unfortunately. So these are the countries that signed the treaty. So you can see there's a couple of blank spots. South Africa signed it right in the bottom. The latest one was, I think, Zimbabwe that joined. Botswana is also there. But most of the African countries did not sign the convention. So the loophole might be, for example, Swaziland or Mozambique. What would happen if you take a child across border? You take them to Swaziland and you fly out from there. Mervyn spoke about the documentation needed for international travel. Our bordering countries, their requirements for international travel with children are not as strict as ours. So we see that often, that people skip the borders of South Africa and flying from adjacent countries in order to circumvent the whole process. Now, these are the countries that are signatories to the Hague Convention. It is also in your handout. You will see that. With the latest one, Zimbabwe that joined, Botswana and South Africa, obviously Japan. But yeah, notably most of the EU country or the Arab Emirates, those countries have not joined the treaty, which is very unfortunate. So what happened is that after South Africa signed it, we actually created an act called the Hague Conventions of Civil Aspects of International Child Abductions, Act 72 of 1996. Ooh, long word. But that act was repealed, and most of the conditions of the Hague Convention was brought in by the Children's Act. And Chapter 17 of the Children's Act now deals specifically with the Hague Convention and the procedure that needs to be followed in these type of matters. Section 274, the purpose thereof, South African legislation now recognizes the Hague Convention as a formal piece of legislation because it was codified and enacted in our Children's Act. Also speaks about legal representation. Just on a side note, with regards to legal representation, if you look at the other countries, they could accept the Hague Convention with certain exclusions. Some of them might say South Africa accepted it, but the exclusion was that South African government would not supply legal assistance, cost-free, to the people wanting to make use of the Hague Convention, unless it's covered by legal aid. Other countries, there are some countries that say that government would sponsor completely the whole process, the cost of the process. But South Africa entered into this agreement and they signed for it with the exclusion of legal costs, only limited to the amount that legal aid would pay, which makes this a very expensive procedure in any event. So in practice, what we see normally, Mervyn made mention of that, is that South Africa, the Office of the Family Advocate has been dedicated as the regulatory body that needs to attend to these type of matters. But we all know that the Office of the AFA is not blessed with speed and efficiency, unfortunately. So what we see quite often is that we rather bring an urgent court application in asking the court's permission and instructions so that the Office of the Family Advocate should get their arse into gear and actually do something about that. Because the children, if they are South African citizens, are still the upper guardian of the children. So we see that usually during December, January holidays, we see most of the time we see these types of applications. So the whole basis upon which the Hague Convention or these type of applications are based is based on the concept of guardianship. So if you want to change guardianship, you need to go to the High Court. Henceforth, we approach the High Court. There are changes in the pipeline in the Children's Act to have that change so that the Children's Court could also attend to these type of matters. The reason why I say that it is all about guardianship, because it goes and it speaks to the consent that is needed for the departure and or the removal of a minor child by the guardian from the borders of South Africa. That's why I make mention thereof. Obviously, these type of applications can be opposed. It is not cast in stone, although the central authorities of all the countries working together needs to work towards bringing the children back and maintaining the status quo like it was. There are instances where these matters could be opposed. The convention makes it mandatory that the judicial officers or authorities needs to assist to bring those children back. I said that. Obviously, the courts in those countries also have a discretion when it comes to making such orders. It might be mirror orders or it might be the normal Hague Convention orders. So amongst these, one of these popular defenses that they use, and we see that mostly probably in every application, is where the child objects to being returned to the country of origin, where they are habitually resident. So the voice of the child is also being heard in these matters. So if the child strongly objects of going back, then that must also be taken into account. Is that fair? It still needs to be debated. I'm thinking of cases like in Australia that I know of about child abduction and parental alienation. Those things all come into play. So it might be a little bit of a tricky ground to navigate these type of matters, especially when they say that it is the children that is opposed of coming back to South Africa. So what happens now? I said that there's 103 countries that signed the Hague Convention. What happens if you don't have a country, like in South Korea, for example? If you don't have it, if they're not a party to the Hague Convention, then you need to go through the long process, like Mervyn explained, to get a mirror image in that country. That is an expensive procedure. It is a very expensive procedure because you need to have its documents sworn translated here in South Africa, apostilled, and then sent through, and it is a whole process. Could it be done? Yes. Is it an expensive procedure? Yes. I'm not here to lie. That is an expensive procedure. So the best would be is to, if they are in a country that are a signatory, then your chances would be better as opposed to when they are not. The central authority in South Africa that deals with these type of matters, like I mentioned, is the Office of the Family Advocate. And they are supposed, even if they get an application from Japan or from any other country that is also signatory of the Hague Convention, then they have to assist to discover the whereabouts of the child, to prevent any further harm to the child, to attend to secure voluntary return of the child, or otherwise initiate or facilitate judicial measures that the child needs to be returned to the country of habitual residency. And then also to provide or to facilitate provisions of legal aid and advice, but only to the extent that legal aid would pay for that amount, not the full cost. Like I mentioned, South Africa, the Family Advocate has been appointed as the central agency dealing with these matters. So who can bring that application and when can you bring that application? A child needs to be less than 16 years of age. So if a child is 17 years, then you cannot make use of the Hague Convention. A child needs to be 16 years or less. My experience is that these type of matters usually drag on for at least 8 to 9 months, even more. It could even be longer. So the chances are that the child will turn 16 during that period if they are 15 now or 14 is quite good. This process should actually be a very expeditious process, a fast process. But in practice, we see that it is actually not the case. The person applying for the return of the child must have the right of custody. So that person that brings the application needs to be the guardian in terms of the law. Like I said right a while ago, it's all about guardianship. So the person that brings the application would be the person that has custody in respect of that time, at the time, and that should be at the time of the wrongful removal or the retention of the child. Visitation rights, it's got no play here. Visitation and access rights has got no bearing with regards, and it's not even considered, because the main reason why we use the Hague Convention, it's all about guardianship. So the visitation rights that you have, so if you're allowed to go to visit your ex, or the children is allowed to visit your ex in Spain, the visitation rights has got nothing to do with the guardianship component thereof. Another provision is that the child must have been habitually resident in the country, for example, South Africa, when the child was removed, and that there must be an agreement between South Africa and that country. So they have to be a signatory of the Hague Convention. There is a form, nothing stops you from doing this whole process yourself. There's a form 10 that needs to be completed and to be handed into the Office of the Family Advocate. They do tend to these type of matters, but we see in practice that mostly the High Court is approached for immediate relief, forcing the Office of the Family Advocate to attend to these matters. But yes, the Form 10 needs to be completed, and there are certain details that need to be filled in. I'm not going through the form. It's a typical government form. And yes, you do actually need a PhD form to fill out the details of the form. It's a government form, so it's, yeah. Documents that needs to be supplied with these applications, the normal stuff about the proof of address, photo of your children, they require that. The application for legal assistance, if it's at all necessary, translations of the documents. So if you have a set of documents that you need to submit in order to substantiate your application, it needs to be translated in the language of the receiving country. So it would not help if you try to do an order, Hague Convention order in Tokyo, and you draft your application in Afrikaans. They would just look at you and say, no, they wouldn't say no, it's Asian. No, something like that. Yeah, but those are all the documents that you need to submit with your application as well. What we've also seen is that people struggle with the word, what is meant by being habitually resident in a country, because that is one of the requirements before bringing such an application. So the basic idea is that wherever your child is settled, but it is also considered to be a gray area. So where the child is settled, and it does not necessarily pertain to where they were born or what their passport says. It is where the child is usually settled. I've mentioned that one of the defenses are that the child objects to coming back to the country or going back, forcing the other parent to go back to that country. So there are 5 defenses that the courts would look at and consider when it comes to child abduction, specifically with regard to the Hague Convention. Number 1 is the time limit. If you have stayed in that country, if the child has stayed in that country for a period longer than 1 year since the removal of retention, that would be considered to be a defense. So do not wait. If you have such a client, if you have a client dealing with these type of matters and they come to you, act on it as fast as possible. Do not wait till month 9 in order to institute proceedings. Because one of the defenses are the time limit or the time constraints for a period of 1 year. So that it should be lodged within 1 year. Otherwise, why? Why would it be considered? Otherwise, they would be considered to be habitually resident in that other country. And that is what you want to try and prevent. Custody, now we're talking about defenses. The person requesting return did not have the rights of custody. So if the person just has visitation rights or suspended or even terminated parental responsibilities and rights, that could be a defense to say, but you know what, you cannot bring that application because you are not considered to be a guardian in terms of South African legislation, which is quite straightforward. Another one that is also used quite often is danger. if there is grave risk for the child of returning to the country of habitual residency. The court would entertain that as well, and then the court would make an order to say, but you know what, the child needs not be returned. Objection of the child, obviously, yes, the children will be heard in the process, and then the last offence would be defence, where the person requesting the return consented to removal of the children. So it's usually that happens with, especially the holidays. You know what, I consented that the children could go there, but your consent only stretched for a certain period of time. You know what, you had to bring the children back by the 3rd of January. It's already the 17th, and you have no intention of bringing the children back. The court would definitely look at that as well, and the court would not consider that to be formally consent, that you are allowed to keep the children there if it was for an extended period of time. These are the cases, the South African legislation. I'm not going through that. There's a couple of cases. We see many of them in the High Court. Interestingly enough, the Hague Convention also is very prone to mediation. If we just bring it back to mediation, like Natalie said, and they are very keen that people, especially with these type of matters, mediate the matters, and it could be done. It could be successfully done via, nowadays with all the social media available, all the platforms available, Zoom, Teams, StreamYard, and so forth. We can mediate resolution between the parties in bringing that child back to South Africa without the need of having the authorities intervene to bring that parties back. And the Hague Convention, they actually brought out a guide of good practice with regards to that, and that was 1980. And they offer, for mediators, qualified mediators, they actually offer a course on the mediation structures of how to deal with the international mediations of a child abduction. If any of you guys would like a copy thereof, just drop me a mail and I'll send you a copy of the training material, which I have, as well as the guide that they have presented. Lastly, to bring it back to maintenance, I just want to make mention, John asked me to make mention of the Hague Convention on the international recovery of child support and other forms of family maintenance. Guys, there is actually a treaty or a convention, a Hague Convention on international maintenance, very similar to child abduction. You know what's the bad news? South Africa is not signatory to it. And the reason would be why? Why would we not engage into something stunning like this? These are the countries that signed the treaty. Not a lot, though. Not a lot. Strangely enough, most of the European countries signed it. African countries just point blank ignored it. Australia did not even sign that, but we know the Aussies is down under. They're just difficult. Korea didn't sign it. Japan also did not sign this one. But this is an instrument that South Africa could look at. It is available. It is considered to be international law. In terms of the Constitution, our courts, when bringing an application, may use or may take cognizance of international instruments, such as treaties, conventions, and intercontinental agreements. They must include, and they must listen to the reasoning of customary law, and they may use international law. So there would actually be no reason whatsoever why this treaty, this convention, could not be enforced in South Africa. We just need a couple of family law experts, Mervyn, bringing such an application before court, because it is available. Even though we are not a signatory to that treaty or that convention, we might very well, in terms of the Constitution, we might very well be able to use that. That's basically it for me on the Hague Convention. Thank you, guys.
Wonderful. Thank you so much, Mr. AJ. Okay, I'm going to introduce our next speaker. It's one of our own, our ambassador, and she's also a regular presenter at the Dialogues, Ms. Brunel Rath. She's going to take us through section 11.1, travel allowance, and she's just going to give us a quick practical guideline in terms of how mothers or applicants can claim for tax deferred fuel costs and any other maybe lost wages or income while they are busy with the process of maintenance. Ladies and gentlemen, let's welcome Ms. Ronelle Ross, please.
Good afternoon, everyone. I'm not sure what the sound is like at the back. If you can just guide me. Can anyone hear? Oh, okay. Thank you so much. Good afternoon and a warm welcome to everyone, especially with this weather. I know what our Cape Townians are like. If it looks like this, everyone wants to stay in bed. So thank you so much for everyone that's attended today, as well as our online attendees. I want to thank you, the NPA for the facilities. We appreciate that. And then I want to thank Advocate Reuters, Mrs. Natalie Reuters, Mr. Eugene Opperman, Mr. Mervyn Vermeulen, all the way from Gauteng. Thank you so much. And all the learned friends here. I'm not too sure who's attorneys, who's advocates, so apologies if I missed anyone. And thank you so much for all our ambassadors as well, for all the work, let's call it the back office that gets done throughout the month in order for us to have our dialogues. So my slides are up, but I'm going to deviate a bit from that because I'm a bit of a rebel. So I'm going to start off with what Natalie and Mr. Vermeulen touched on, and that is Section 28 of the Constitution that says regarding the maintenance of children, every child has a basic right to basic nutrition, shelter, basic healthcare services, and social services. 28(1)(d), every child has a basic right to the protected from maltreatment, neglect, abuse, or degradation. And then Section 21H, 1H, every child has a basic right, now this is very interesting, to have a legal practitioner assigned to the child by the state and at state expense in civil proceedings affecting the child, if substantial injustice would otherwise result. And I remember Dr. Carmel touched on this earlier, and I have yet to hear about a mother that legal aid assisted the child, as it says in our Constitution. I'm not too sure, there might be cases, but I have yet to hear of that. I'm just gonna, sorry. So I'm not gonna go through the whole Section 28, but there is quite a few pertinent questions. Question 1, why are there no legal representation for mothers in maintenance matters? Instead, mothers must fend on their own for their children, while Section 28(1)(h) enshrines in the constitutional child's right to be defended for his or her for maintenance. This is not being done. Where is legal aid in civil attachment matters? Where is legal aid to secure a mother who do not have to pay Section 20 in the WhatsApp support group? After months of actually getting an order against the respondent, now they must still pay sheriff fees. They don't even have enough money to feed a child. Where will they get money to actually pay the sheriff fees? I just want to mention that it is possible to ask the court to assist you as the mother or the applicant with, if you can't afford those sheriff fees. So I'll touch on that later. Sorry, let me just get to Section 11(1). So rights and privileges of witnesses. Okay, so I'm a layperson myself, as everyone knows, but it says any person other than a person against whom a maintenance order may be made under this act. So I'm going to stop right there. Any person. So if someone in a maintenance office tells you, oh no, that's not for you, that's for the respondent, it says any person, and the mother is any person. Attending the inquiry as a witness shall be entitled, and shall and must, if I understand the law correctly, it's the same thing. It's not may, it's must or shall. To an allowance as if he or she were attending criminal proceedings as a witness for the state. The maintenance court may direct that any person against whom a maintenance order be made under this act shall be paid the prescribed allowance for subsistence and for travel to and from court. Shall be paid such allowance as may be paid to witness for the accused in criminal proceedings, and shall be paid such allowance as may be paid to a witness for the accused in criminal proceedings. Recommendation: any person includes a mother applying for the Section 28 rights of the child, as mentioned before. Why are mothers being punished for standing up for the rights of their children? So we're going to look at the problem. The problem lies in the regulations omitted. So the mother is omitted from the regulations from Section 11.1 if it says any person. Regulation 5 only provides for the person against whom a maintenance order can be made, the respondent. Regulation 5 provides for a respondent, not the applicant. That is why maintenance courts do not provide for subsistence and travel allowance for mothers. The proposed action, as discussed by Advocate Reiters earlier, is to bring all these matters before the Law Reform Commission and Paper 157, to write a submission requesting an amendment to Section 11.1 to include the mother's right to subsistence and travel allowance, including taxi fare and loss of wage. How many mothers are sitting at the courts losing a whole day's wage, need to travel there? They just need to find the money from somewhere. I have heard Advocate Reiters discussing the option of, if you know you're going to be there the whole day and you're going to lose a whole day's wage, ask your HR manager to give you proof that you have that's unpaid leave for the day. And then in return, I'm going to discuss the affidavit now, how you can actually request this from the court. But that's what we mean with the subsistence allowance, is that wage that you lost for that day. I'm going to get to the affidavit now. And then proposed email to the South African Law Review Commission. I'm just going to, okay, sorry about that. That looks a bit different than mine. So it came to our attention as concerned mothers in the Maintenance Court of South Africa that, first of all, the Maintenance Act 99 of 1998 provides for subsistence and travel allowance in Section 11.1, but Regulation 5 of the Maintenance Regulation Act do not provide for mothers exercising the children's constitutional rights in Section 28. Section 28H provides for legal representation for children, as enshrined in Section 21 C, D, and H. But legal aid, like everyone is aware, I've yet to see a case where legal aid provided legal assistance to the child. I'm not saying it has not been done. I'm not aware of that. I want to take everyone quickly through, just want to quickly go out here. And I do apologize for all the legal eagles sitting here. I understand you know exactly what to write in the affidavit. I'm not going to go through a whole affidavit, but the affidavit for everyone here that has never submitted an affidavit to the maintenance court can be found on the website www.childmaintenance.org.za. you'll go to the public tab on the page, and then it will show you, there's different sections. Some of it is case law, some is affidavits. There's a section where it says affidavits, and then the affidavit is called affidavit loss of wage and subsistence and travel allowance. So all that you can do, it is a Word document. You just you just put your own details in, but the affidavit is drawn up already. Thank you so much for Mr. Eugene Opperman or Advocate Reuters. I'm not sure whose affidavit this is. I'm just quickly, so I'll be quick. So I do apologize to all the legal eagles. I understand you know what to write there. I just want to make sure that everyone here that's not in a legal fraternity understand that as well. Like myself, a layperson. So in your affidavit, you will say, I'm an adult, say female, residing at wherever, and then you'll mention Section 11 of the Maintenance Act. And it was, so what I just discussed with Section 11(1) of the Maintenance Act, it says any person other than a person against whom a maintenance order may be made under this act, attending the inquiry, which the mother is obviously attending, as a witness, shall be entitled to an allowance as if he or she were attending criminal proceedings as a witness for the state. My expenses to the court, then you calculate your own expenses. So you go through and you'll see on the affidavit, oh, there it is. That's it. Thank you. So your daily wage, so that you'll get from your HR department, you calculate that, you include that, and then obviously your transport. Let me just get to that. So it will say loss of daily wage, annexed year 2. Please find an affidavit from the human resource manager at wherever your employer is, confirming my daily wage and that I'm not using paid leave. So in other words, it's unpaid leave. So that is what you're claiming from the maintenance court. I've been through the maintenance system myself. I did not know about this. And I'm sure many applicants in South Africa is not aware of this. And I'm sure courts will not inform applicants that you can actually claim this, but it's in the Act. So use the Act. What I always tell everyone is, if you don't know your rights, you cannot enforce your rights. And yes, we are not legal, we're not in a legal fraternity, we are lay people, but that's why we are here. That's what the community dialogues are for, is to educate everyone so that everyone can understand that. Section 11(1), it does allow for subsistence and travel allowance. Please make sure enforce your rights. I would say, if you go to court, have your affidavit ready for that maintenance officer and make 2 copies. Let them stamp it so that you're sure that it is in your maintenance file, because we've all heard that story as well. Oh, I can't find it in your file. Make 2 copies, make sure they stamp both copies so that you are sure that it is in your file. I want to thank you. I'm sorry if I missed some of it, but oh, you have a question.
Can I just ask questions? Who do you claim against, the state or the respondent? And how does that process work? Do they pay you immediately, or do you have to wait for 10 years? The state, they didn't pay, they said they didn't have money, so
Thank you for your question. Good question. I'm just going to reiterate for the online attendees. I can't remember your name, sorry. Ashraf. Ask, so who do you claim against? Is it the state or is it the respondent? And when do you receive the money? Am I correct?
Yeah.
So you claim it against the state. So you claim it at court, not the respondent. And Advocate Reuters, I'm not too sure, but I think, but he must please correct me if I'm wrong, I'm sure the maintenance officer can actually, if you ask for your travel allowance, if you have your proof, they can pay out immediately, if I'm correct. Okay, so you see, so that's what I'm saying. please go to the court and ready. Have your affidavits ready. It is on the website. Just change the details. Your details will be different than anyone else's. Go there with 2 copies. Make sure it's stamped. Make sure it's in your file. Because we know about the lost files and can't find this. And you've seen, I'm sure everyone has seen, I'm not sure if it is, but it looks like Randburg's court filing system. So if that is anything to go by, then we have a big problem. And that is the reason why I'm saying, please go to the court with your affidavit, 2 copies stamped, 1 in your file, claim your subsistence and travel allowance. Thank you so much. Thank you.
Great, thank you so much, Ms. Ronalva. Ladies and gentlemen, I know it's been a long day, but I would like us to just to encourage us to open our hearts and our minds for the next speaker. It's an honor to actually welcome Mr. Daniel Den Hollander. He was here last month and he is here to conclude his talk on the challenges and the complexities that South African men are faced with post-apartheid. Thank you very much for sowing into this movement. Ladies and gentlemen, let's welcome Mr. Daniel Den Hollander, please.
I'm just gonna have to make sure. Can everybody hear me? That one for here. The online can hear me at least, and the rest of you. Okay, we're gonna have to see how we do this. Maybe I must. This is interview with Rassie van der Dissen. We had to sit almost like a giraffe just to be able to speak into the microphone, and I get a taste of it. Thank you for the opportunity. I think this is a bit of a different flavor to the presentations that you've had up until now. I'm quite interested about how we in society, even though we're in a post-apartheid South Africa, we're still very much dealing with the same wounds, the same difficulties. And as a psychologist, that's my trade, you know, we have the absolute luxury of not only sitting and listening to people, but actually taking time and struggling with people. Currently, I'm really being looked after by the community in Athlone and Lansdowne. I think I've now become an honorary member. I think I've now become adopted. And on that note, I just want to wish those brothers and sisters of that community a very happy Ashura today, where we're celebrating the parting of the Red Sea. So just that little bit as well. But I'm going to talk a bit about today about something. Ooh, see, we got WhatsApp instead of. Lovely. Something that I was picking up just after lockdown. So a lot of my slides and presentations are very much informed by the clients that share their lives with me, with their permission, of course. And often what happens with us is that we start to see trends that happen within our sessions within individual clients. But if you see a lot of them, then it starts to talk a little bit to a bigger, how would you say it, a bigger scope, a bigger audience. And this was something that really came out from there. So we're going to start. Are we ready? Say it again. You can just start the slideshow. Yeah, perfect. Can everybody? Okay, perfect. So this happened sort of August 2020. It was about a year, or let's say 7 months into lockdown. And I was getting a high flux of middle managers coming into the practice for symptoms consistent with burnout and a depressed mood or depressive episode. That means that's not necessarily meaning that people are sad. It's actually the opposite. It's that you're completely and utterly blunt and completely suppressed in regards to all types of emotions, completely out of touch. Okay. And all the, you know how psychologists are, the first thing we ask is, so tell me about your parents, and then also, is there any traumas? And ironically, no, happy family set, or relatively happy family setups in South Africa. We do have difficulties in regards with families, as we spoke about in the previous presentation. But also the family support that they had was there. In fact, they were also part of being burdened. And so it didn't really come from the areas that I would have guessed would be the areas that would start that kind of presentation. And there was a strong identity component to the presenting problem. And two things we were picking up, something called learned helplessness. And just to explain what learned helplessness is the idea of I can't. So anything that comes onto me is just something that I immediately want to give to somebody else to do. Because I'm unable to. But when we investigate, you are able to. You don't have a disability as such. It's much more on an inability to be able to take anything on. But there's no physical reason as to why. And from psychological, it's a bit tricky. So what's going on? And it's got a lot to do with if I delegate it off to somebody else, then I don't need to take charge of it anymore. So it's more of an abdicating of the responsibility, if that makes sense. And then disempoweredness and defeated. And there was another thing that all these people had in common, and that was that they were middle managers or public sector employees. I'm just checking if we have any public sector employees in the building. Because this is the conversation we don't like to have, but this is exactly the conversation that we need to have. I almost want to call this next three words the motto of public servants. Whenever you see public servants, and we can test the room here to see if you say the same. They will say, if you ask, how are you? They say, no use complaining. What's the use, right? Thank you. Okay, so this is the part. Okay, unfortunately, I had a bit of a situation this week where my laptops have gone completely missing. I'm hoping it's not thefts and they will come up, but want to really thank Natalie for making sure that they're all there. But these slides are as interesting for me as they are for you. I hope everything works. So press play. You can go to the next slide. So what am I seeing? I'm seeing a patterned response that specifically aims to middle managers. What is a middle manager? Anybody who has people working underneath them, but also has to report to a higher structure. So that's probably everybody in this room who's not having their own private practice. And my question was, is this possibly a response to the dynamic consistent within that working role of the middle manager? And these slides started off with reading an interesting article on LinkedIn, but totally culminated into lots of hours of struggling with clients around these slides. So this has really been the culmination of I would say about probably 40 or 50 different clients looking through this, struggling it with me, and this is what we came up with. You can go to the next slide. So, okay, this is going to be tricky. Okay, so that over there is a diagram that I want you to start getting used to. So the top part, the blue part, is how your employer treats you. And the green part is how... Let's see how we can make this more tricky. Okay, now we're with ESCOM. We're going to pretend that we're not going to be paranoid at this point in time. Okay, how are we going to do this? Just carry on. You've all got the slides with you. Is it just going to kick into gear again? Okay, perfect. Okay, so what happened was, okay, you all got the slides here, and I need to introduce the slides to you, and I don't have the slides, but they'll come as it goes along. But if you look in the diagram, so the blue, we all have it as black and white, but the blue part is how your employer sees you. the bottom part is how your employees respond to you, and you are that red pressure point situation. Does that make sense? Okay. So from the top, we feel a pressure because the expectations of our employers are fortified through the policies and the core standard documents that they send to you. I used to work for the Department of Health, and those core standards felt more important than the ethical code from HPCSA. It worried the hell out of me because I was being told how to do my craft by people who don't understand how to do my craft. And especially in psychology, we have an old saying that says that trying to govern psychologists is like herding cats. So, but that was exactly what was taking place. And these core standards actually didn't talk to the services that I was doing, and yet I had to follow them to the T. Then at the bottom, the people that I'm responsible for, their expectations are fortified through morale and productivity. If I don't make them happy, then their morale goes down, then they're not productive, which now becomes my problem, right? And often the problem is that they're actually not happy with each other, but they don't want to talk to each other, or they're not allowed to talk to each other. It's much easier to put somebody in that place, and that's where the middle manager is, and that's where the pressure point is. That all makes sense, right? Okay. Oh, I really need my slides now, but it's okay. So middle managers, are they gonna come back on now? Okay. So here was an interesting thing, an interesting quote. Middle managers have a complicated relationship with power because power is activated and experienced in the context of interpersonal relationships. When interacting with our superiors, we immediately take on a more deferential, low-power behavioral style. You know, I'm sure you've all experienced that when you talk to your CEO or your manager, you become a lot more, what's the word, polite. When interacting with subordinates, on the other hand, we adopt a more assertive, high-power behavioral style, where we're much more assertive, we're much more boundaries, and we say things in a much more particular way, right? The difficulty comes in is that often in meetings, we have to do both at the same time. And that's got a lot to do with the fact that often we are told that when we go into meetings or whatever the case might be, that everything just seems to be a bit squashed through. And so we find ourselves almost in this very sort of psychotic, schizoid position. Next slide. Where this all becomes uber confusing. And failure to conform to these role-based expectations can lead to social conflicts and confusion. And that's often what does take place within our meetings as well, is where we have to take charge of something, we get nullified just beforehand, lose all our power, and then what? And then that becomes a big issue, and then we try and reclaim it with a little bit more assertiveness, and then we are having a disciplinary hearing. So these things become very tricky. Next slide. So how do the others relate with us? Well, from the top, often the interactions are top-down.
Go ahead.
Often we are communicated through this sort of absurdity of scores and ratings. I'm sure you know, all familiar with it. If they're upset with us, they usually communicate through disciplinary hearings. Top down, meaning that you're not there engaging equal to equal. Often low support with explanations, which you have to understand. There's no budget. How often do we hear that? But then there is budget to tile the car park, but we have to understand that's because it comes out of a different account, and then also often very forgiving, but with consequences. So if we are unable to do the core standards, they forgive us, but there's consequences to it. They understand we don't have enough people in this section to be able to do the job, but we do have to rate your department now 2 out of 5, and this might impact your ability to get how much is it now? 3%, 2%, 7%, whatever the increase is. At the bottom, we're sitting with people who are overwhelmed and desperate, threatening union action if we don't abide to the needs. I can see, okay. Needs to be convinced, and you sit there with your employee, with the people underneath you, trying to convince them, giving pep talks from another lands, Amandla, but end up with poor morale, and poor morale equals poor productivity. And if you have poor productivity, it's not the fact of the system, it's your fault. And so you sit here, and these guys over here just want money if they're in private, or just want recognition for ambitious reasons. Let's call a spade a spade. At the bottom here, we're dealing with ethics. Sometimes somebody is a little less productive because they've got to take their kid to the doctor, and you've got to be that person, because these guys are not going to be it, who says, yeah, but it's now the third time your kid is sick. And it's very inhumane, the positions that we find ourselves in, and we often find ourselves squashed between efficacy and ethics, because these guys want you to talk to these guys, and these guys want to talk to you about these guys. So you're completely squashed between these two conversations. Okay, let's see if this works. Yeah, so these are the managers who are left to explain to the staff about budget limits, regulatory mandates, consumer satisfaction, and yet in those circumstances that they cater to both ends, this is the important line, their own working conditions are neglected. And there's a whole bunch of movies like Office Space, I think was one of them, that make a lot of fun about this weird dynamic that we find ourselves in. In South Africa, we just embraced it. I mean, of all the things that we had to continue using that was still there from the old regime, why was it bureaucracy? For goodness sake. It's so un-African, if I may say so. And then comes this graph. Now you see where the psychologist comes in, is that for me, this is the humanity graph. This is where this ends us up. And remember, if we in these systems, we spend an exorbitant amount of time in these systems because we're there from 7:30, then we're allowed, 15 minutes for a cup of coffee, then we've got to be working. Then we're allowed half an hour break, but that cuts into the hour break at lunch. We spend a hell of a lot of time on this. 8 hours a day, 40 hours a week. It's going to have its impact that if this is the kind of humanity that we're working into, this becomes the kind of humanity we take home with us, and becomes the type of humanity that we're held back by. And that's the key thing that I really want to talk about in all of us. So the humanity graph, we see our superiors as detached. They don't understand what it is that we're actually doing, constantly justifying their decisions. Irrationality, rationalized. You must be able to produce X amount of work without the staff. How? Guys, there's no budget. We got to make a plan for the people of Africa, you know? Decisions that they make without consultation. Ambiguous instructions that don't mean anything. I've experienced that a lot with DOH, where the CEO would tell us instructions, and I'm like, how? And they said, well, it's not my scope of practice. Fostering favoritism. You see, this is one of the things, and this is the difference between public sector and government, or if you like, private sectors and public sector, is that private sector, you've at least got one thing working for you, is that if all else fails, the profit line of your business is the thing that's going to rescue you as employees. Because if your productivity is not high, the profit line will always supersede your manager's ideas. So if you're going to work in an inhumane way with inhumane conditions and your employees get disgruntled, your profit line is going to suffer and someone's going to kick in. But in public sectors, there is no profit line. You argue budgets towards treasury. And as a result of that, that one thing, the productivity and the morale, whether or not you are doing a good enough service or not, doesn't make an impact on the business's health. So in other words, efficacy, which is about money, economics, is not the driving force in public sector. And the important thing is then what is? And that's got to do with how that system actually, if we start to critically engage with it, we know that those positions are filled I'm waiting for someone to say it, by who you know, okay? Now, if we start talking about who you know, then we're talking about popularity and charisma. And if we're talking about popularity and charisma, then the idea of success is about how well you can sell yourself as a political game. You get what I'm saying? And that is a very important notion to put through, because that's where that's where the favoritism comes in, because it's about charisma, and charisma can what's called hide the cracks of a non-efficient system. And so then economics and efficiency goes out the window. Ooh. And then the last bit as well is they always talk from a very idealized perspective, as if we have everything in place. So those cores and standards documents that you are told to do are all about the ideal. But then there's also this other trick that takes place where if you say, well, listen, we actually need like maybe twice as many psychologists in the hospital, then they start saying, no, but you're talking from a very idealized perspective. You know, we're still living in South Africa. And then from the bottom, we've got individuals who are often jealous of us. We're in a middle manager system. Why should we be? Why were they not? Untrusting. Do they really have our intentions at hand? Often they're angry and disgruntled, especially if we've refused to leave. There's always this threat of mutiny, you know, we're not going to talk to you, or the silent treatment that comes in. Then it is the fact that a lot of the working conditions are difficult. So then we sit with employees that are stressed out, and we get absenteeism. And also some of it is active. We find out we have to go in for trade union hearings, or it's passive, which is our fault again, because why are the employees not doing what they're supposed to do? And so we find ourselves between being the enforcers. This over here wants to enforce this towards realizing that these are human beings, and there's empathy coming back towards them. You can see what this does to you as the middle manager sitting in the middle of it. By virtue, they are simultaneously the victims and the carriers of change within an organization, receiving strategy prescriptions from their bosses above and having to implement those strategies with the people who work beneath them. Okay, I think there's another one, but I'm not going to go there. Okay. Oh, yeah, no, there is one thing I want to. Just this. So a study in Colombia found middle managers to be the most stressed in the chain of command and twice as likely to experience anxiety than the workers or the owners. Isn't that interesting? There's now research evidence to prove that if you're a middle manager, you've got it worse. So take a deep sigh of relief. You can win your arguments now. You're in the worst position. And it doesn't make sense, does it? Because you would think from economics, the people below you earning less than you have more money, so you should be better. No, this is going to cause you anxiety. And it's not one of those things of, hey, you know, just like suck it up. You know, this is now, you're a manager now you must, We know that the evidence says. So why is this happening? And this is a thing that's, for me, it's about the chains within the system. And for me, chains in the work that I'm doing is stuff that came from previous regimes. And from previous regimes, I'm talking about the legacy of colonialism. I'm talking about the legacy of apartheid, where the way in which people were controlled was more in regards to the structures and the legislation and the bureaucracy, as much as it was physical trauma. And that to some extent, you know, it's debatable about TRC, but although we sometimes are dealing with the interpersonal violence, we never really talk about the structural violence. And it's the structural violence that actually holds us still very much chained up, and is stopping us from progressing into a society that's both empowering and diverse. So we are disempowered when we forget that we are not married to our job. one of the weirdest things that I pick up in my practice is that when people talk about unemployment, it's as if they're talking about life and death. And it's weird because losing your job is nothing like having your life threatened. And yet for a lot of people, it feels as if that's exactly it. We are not owned by our jobs. They can't just get away threatening our jobs. Now, the next line I've got to explain. We are merely chickens who lay eggs for the workplace to become productive. We are not pigs whose existence depends on sacrifice to its owner. Now, that came from a previous CEO that I worked with who stood up and said, I don't want chickens in this hospital. I want pigs. I want people who are willing to sacrifice their careers in order to bring brilliant healthcare towards the whole system. And we all went, man. And the problem is, it's BS. It's rubbish. That's not how it works. We are not pigs. And I think there's a lovely Animal Farm element to that as well. Our existence does not depend on our sacrifice to the owners. But we are stuck and justify our sacrifice to our professions when we allow ourselves to become stuck by the chains in the system. So I'm going to show you 3 chains of the system that I'm sure you're all familiar with, and then tell you why they're lies, and then how to ramify yourself from it. And then I'm going to run away quickly before anybody that's in senior management is going to have a problem with me. Should we do it? Okay. So the first fallacy is this idea of the career progression. You come across this when they offer you that job description. And in that job description, you've got that one section that leads you right from, I remember, from a young psychologist all the way to the CEO of the hospital. I think it even went further up. I think we were allowed to be even the minister of the Department of Health. And there was that career progression for us. And it looked beautiful and exciting, and it's BS. Because a career, and it's BS for 2 reasons. The first one is a career path is not the path to liberation. And somehow the older generation really believed it to be. Remember, one of the chains of the mind that happens often in Cape Town is an old saying that goes, always the foreman, never the owner. I don't know if you know what I mean when I say that. But it means that when you go home to your family and you say to them, I just got this government job, I've got a cushy public sector job, I'm a manager, all the champagne bottles come out, and there's a big celebration, big meal. But the moment you say to your family, hey, listen, I'm about to start my own business, I've got a place in place, all of a sudden, all the aunties and all the uncles are getting very anxious, asking you questions. Have you really thought about this? But if you go and take that job like so-and-so did, you can have your pension and all your benefits and so forth. You know what I'm talking about? Because we're conditioned into thinking that type of way. And the biggest problem is because promotion is a funneled system. So the easiest way to prove that, can I get a piece of paper? Just reply. Yeah. Okay, so how many CEOs are there generally in a hospital? There's just one, right? And how many, let's talk from a nursing system, there would be probably about, let's say, 30 or 40. So if I have to find a shape that best represents a organogram, it would look something like this. Does that make sense? Okay. Now, if I look from the one, I can see everybody, right? But if I turn it around like this, I can only see one person at a time. You see, what I'm trying to demonstrate there is it's only a career progression for one person, not for everybody. Only one person can go all the way to the top. And this idea of us being able to push through the ranks from the bottom to the top requires so many outside factors to fall into place, people to resign or move on to another job, people to get promoted. So once you've got a middle manager that stays there longer than 5 years, they've already clogged up the space, which means that for another 10 people, they're not going to get promoted. So this thing is bullshit. You know, it doesn't actually exist. And we kind of work really hard in order for this thing to exist. So we put a lot of emphasis on the fact of a job just became available. We're going to compete with the other people. We also know that most jobs and most systems that work like this, you want diversity of thought. So you don't want to hire people from your own company. You actually want to hire people from other companies or other places because they're going to come up with new ideas. And so as you see, it's not, this itself is not even a true reflection. It's like a whole bunch of these funnels all happening at the same time. So in other words, a career progression is not going to give you the salary that you want, which is an inconvenient truth. And there's another problem as well. And this talks to the African that should be within all of us, is Biko states that liberation takes place in the hands of the individual. If I'm waiting for all of these things to happen, I'm dependent on external factors in order for my life to increase. And that's a problem, because then liberation is not in my hands. And I think, to be very honest with you, on a Black consciousness note, we should look into, and this I'm hoping if there are influential people who have a chance, if you know what RWAPS means, so RWAPS is remunerative work outside of public service. That is the liberator. So RWAPS should actually be standardized for all employees as a means of empowerment, as long as we can maintain a culture of ethical principles with it. So we spoke a bit earlier about Ubuntu. Ubuntu always has two legs. The one leg is people, the other leg is ethics. We have many examples in our country of Ubuntu without ethics, you know, where it's all about, if you think of gangsterism, it's often Ubuntu without ethics. It's still the brotherhoods, but it's not on ethics. We know how destructive that becomes. I don't know if anybody wants to challenge me on this, but was this convincing enough? Mm-hmm. Okay, so let's do the next one. I'm sorry it's so small. The extra mile trap. So I don't know if you're familiar with something called the PMDS system, the performance management, you know, the one where they rate you 1 out of 5. I think it's actually 1 out of 6, but 6 got reserved for Madiba, so you can't be 6. I've literally heard somebody say to me with the 6, is that, do you think you're better than Madiba? Yeah. So what generally happens, this was a system we did, I'm sure you've got your own variation of it. But the PMDS system is from 1 to 6. 3 is 100%. 4 to 5, you get your bonus. 6, as I said, has been reserved. And it incentives are given. Sorry. If you get a 4 or 5, you get a bonus, right? And so it's incentives that give the allure that you can gain a bonus due to extra efforts. An extra effort is defined as going over and beyond your expected duties, which deserves to be rewarded, okay? So that's the notion that they have. And it creates the illusion of, I'm just going to refer to my notes here. It creates the illusion of an economic incentive for an ethical act. Think about that. It gives the allure of an economic incentive for an ethical act. However, the economic incentive does not come close to remunerating the selfless act that was created in the first place. And this is something that I do in the sessions where we deal with this particular chain of the mind. And I'll say, okay, let's say, for example, you're earning a salary of, let's say, 40,000 Rand a month. And you are going to get a, let's say, 10% bonus on that. Now, you don't get 10% of your year, you get 10% of a month, right? So 40,000 Rand, that gives you a 4,000 Rand bonus. Now, let's work out how many hours you would have to do in order to qualify for that. And generally, we're talking about at least 60 hours of outside work that you would have done in order to get that 4,000 Rand bonus. So now let's talk about 60 hours on 4,000 Rands. What is that? That's 60 Rand an hour. So if you're going to work 60 Rand an hour, you can probably make, let's say, 100 Rand an hour or 200 Rand an hour if you wait tables. Now, the bonus that you were after is paying you less than if you were to wait tables. So the question isn't, should you be upset or angry at the level of bonus at which you get, and should you be fighting for a bonus? The question is, why are you so terrible at engaging and negotiating the amount of money you make? And why are you selling your hours so cheap that you're willing to do a expertise leveled work for 60 Rand an hour? You see how the conversation then changes, because then you recognize that your hours are precious to you. Because remember, if you're working overtime, where you're not spending your hours? With your family, with yourself, with fitness, with whatever it is that you enjoy to do. And that's where you're actually stealing your time and your effort for 60 Rand an hour. I just want to see from a show of hands, who here would work for 60 Rand an hour at a high level of expertise? And remember, that's for somebody who's earning at a 40,000 Rand mark. The lower that goes, if it's 10,000 Rand, it just becomes ridiculous. We're working for like R1 an hour. And it's because we get sucked into this concept of bonuses and that we absolutely miss that chain of the mind. And it's such a derogatory thing. And then on top of that, we get told bonus is not a given, it's a privilege, which cheapens act of humanity into a drive for money. I didn't even care about the bonus when I did it. You told me that I might be able to apply for a bonus, and now you're cheapening me with money. And it cheapens recognition, because now if I'm the one who feels that I want to do something with a certain community or a certain thing that I need ahead of me, then my colleagues are going to go, oh, you're just doing that to get the bonus. So it cheapens me to being a psychopath. You see what, and then that never gets discussed. It's always discussed in the corridors. Oh, look at so-and-so, because we don't talk to each other. Look at so-and-so. They're just trying to suck up for a bonus. And then the last one. Everybody happy with that? Anybody want to contend? Okay, the third one is, you should be grateful for what you've got. How often do we hear that? Especially within our families and within our communities. At least you're not like so-and-so, you got a job, you got your promotion, just be happy with what you've got. And I'm quoting Biko here, being part of an exploitative society in which we are often the direct objects of exploitation. I don't think this has changed. I think sometimes in the work conditions that we are in, we have become the objects of exploitation. We need to evolve a strategy towards our economic situation. We are aware that the disempowered, our communities, are still colonized, even within the borders of South Africa. I know that this was written in apartheid days, but I think it's probably still even true. How did we miss that other colonization that happened around the mines, the uranium mines? Their cheap labor has helped to make South Africa what it is today. Our money from the townships takes a one-way journey to white shops and white banks, and all we do in our lives is pay the white man either with labor or in coin. I still today see on the highway in this freezing weather that some people find it acceptable to put human beings, brothers of theirs, in the back of their trucks, driving it's absolutely ridiculous. And those people are freezing, and it's okay, and it's just accepted, and nobody's upset about it. Or the other thing I remember when I was working in Umlazi, which is the biggest township in KwaZulu-Natal, and there were people who the shopping center where you could buy your groceries from in Umlazi was a super spa. There's something very wrong about that. And the owner was not of the same skin color and culture as the people that were buying from his shop. On the other side, we have in Lansdowne a Woolworths. And that talks about something else happening, that now communities, people that were from communities, left the communities in search of Claremont and all the rest, realize those communities are boring as hell and are coming back into Athlone and Lansdowne, are starting to generate income within, to the point where Woolworths is willing to invest into Lansdowne. So there's something else happening there. But there's a question mark that we've got to ask about this. And this is coupled with the overt arrogancy of white racism have conspired against us. Thus, in South Africa now, it is very expensive to be poor, and I don't think that's changed either. It is the poor people who stay furthest from town, therefore have to spend more money on transport to come and work for white people. It's the poor people who use uneconomic and inconvenient fuel, like paraffin and coal, because of the refusal, well, we can almost put in the word municipalities of the white man to install electricity in black areas. So there's the poor people who are governed by many ill-defined restrictive laws and therefore have to spend money on fines for technical offenses. We saw that a lot in lockdown, how many taxi drivers had to pay fines for overloading people. But the flow of transport, although I know it's a risky thing to say, but the overflow of transport has never properly been addressed. And there's a problem there. It is the poor people who have no hospitals and therefore exposed to exorbitant charges by private doctors. Poor people who use untarred roads have to walk long distances, therefore experience the greatest wear and tear on commodities like shoes. Poor people who have to pay for their children's books, while others get them for free. It does not need to be said that black people are often poor. That comes from Biko 96 and 97. And this is another thing that he said, and I love this. Content is a part of the trap. Why should you not be grateful? You should always aspire for more. Why? Because content is a part of the trap. And aspirations, ambition, allows for innovation, especially if the ambition is internal, your ambition. When you're ambitious with somebody else's money and somebody else's time, that's another story. But I'm talking about ambition of your own time, of your own money. And innovation is part of the natural development of any culture. A culture is essentially society's composite answer to the varied problems of life. Isn't that a beautiful definition of culture? We get so stuck on the cultural thing, don't we? I think it's because of the need that we have to be able to hold on to our whatever it is that we've got, because it's not always very obvious. But I'm so happy that Biko wrote this, because I can quote him on it with a bit more confidence. But a culture is essentially society's composite answer to the varied problems of life. We're experiencing new problems every day, and whatever we do adds to the richness of our cultural heritage, as long as it keeps the human being at the center. And that's also something to do, we can talk about our own cultures. It's important that cultures shift, but we can also talk about the culture of an organization. We can talk about the culture of public sectors. We can talk about the culture of a company. Those are cultures within themselves as well. And this is the important line that you can retort back next time you're told to be content and happy, is empowerment is wanting to change the poverty trap, not only being content to escape it. And that calls for especially what we like to call the privileged people. Privilege creates responsibility. We don't have the luxury of sitting back. We have to start to address these things because we are in a position to be able to talk and be heard. Well, I'm trying. Okay. And the problem here is it overspills. It has the potential to threaten the balance of the individual. I become a working person and think back about the middle managers that I was seeing. I'm depressed. I don't feel like I'm alive. I don't feel like I have a purpose. it has the potential to threaten me, but it also overspills into the work-home boundary line. It threatens the ego of the manager, which threatens the integrity of the manager, and incentives cuts into family ties. So you see, there's a lot of other things that are going on, which makes it difficult for us to just leave it at the workplace because it kind of starts to creep into identity. I hope I've got enough time just for a few more. Oh, they're going to leave. Okay, perfect. So this slide is about how does this thing that's happening at work start to mess me up when it starts to become personal. So you've seen this already. So what happens is this part over here and this part over here never talk to each other because this justifier over here stops them from doing so. You get paid however much money you agree on being abused in this way. That's literally the definition of a manager, right? So there's a chasm. Is that the right way of pronouncing it? English is my second language.
The teacher says yes.
Chasm. Okay. There's a chasm here that becomes internalized. So this chasm becomes internalized. Top is ego-driven. Bottom is emotive-driven. Or if you like, emotive is what allows us to know that we're okay and everybody else is okay. So that's the humanity. So when my ego and my emotions are not talking to each other, when they are talking to each other, so if management and the employees are talking to each other, then we have a stable and balanced core that is established. But once these two start to not talk to each other, then we have conflict. And if we have conflict, that's where a lot of the pathology takes place. And I was like, but this looks so familiar. And why does it look familiar to a psychologist? Because that's exactly how our bodies work. If I'm feeling tired, my body is communicating to me, I need to go and sleep. What do? We drink coffee. What is coffee? Coffee is not giving you energy. It's a chemical that you drink that tricks your brain into the same thing that you do when you yawn, which is tricks you into thinking that you're now in a waked up phase. It doesn't give you energy. It just tricks your brain into thinking that you're awake. That's why when you drink too much coffee, you're very, very tired at the end of the day because you're constantly tricking your body to use your reserve energy. Same with cigarettes. People who smoke, generally, if you haven't smoked for a while and then start smoking again, you realize that by 4 or 5 o'clock in the afternoon, you're more tired than you were previously because you're tricking your brain into thinking so. So what you're doing is you're overriding your brain. Now, why are you doing that? Because I need to get this deadline in. I need to get this thing. This guy's phoning me. There's now WhatsApp happening. And especially post-COVID, the way that we are abusing people with WhatsApps and insistence is inhumane and disgusting. And in a body, when I'm constantly not listening to my body, and I do that for a long period of time, that's how you develop things like panic disorders, the more profound stuff. In its worst form, that becomes psychosis. Especially, it lends yourself forward towards substance abuse and addiction because it takes some of the edge off. Have you ever heard that? I just needed to take the edge off. That's where pathology is developed. And I'm worried because I think to a very same extent, we might be living and working in working conditions that is actually developing pathology for us. I'm not going to go into those quotes. And within the South African context, we have a history of the struggle between disempowerment and agency. Because here's the other problem. There's nobody that you can actually complain to that's actually going to listen to you. But it's true. And the reason is because the system was designed like that. I mean, if you were sitting there as a parliamentarian for the National Party in the 70s, and you wanted to put through a law, and you knew that you were backing up the minority against the majority, what you don't say to the majority is no. What you say is yes, but you need a blue form with a red pen, with a black sticker, with a yellow. And every time that they come back with the form, you just say, you forgot this. or the stamp has the wrong dates, go back to that person. So what you do, there's a beautiful portrayal of this in the movie The Hitchhiker's Guide to the Galaxy, where they mock it. You know, there's a guy who's going to be executed, but if they just have everything in place, and they make it in the end, but it's hell. And it's exactly that thing. It's not saying no, because if you say no, then you've got conflict. So you say yes with conditions. It's worse than saying no, because it takes away your opportunity to fight. And that's still in existence now, is that kind of thinking of bureaucracy. You get to the point, and then it's this person is sick. And a structure should be able to say, if this person is sick, then that person takes over responsibility. No. We have to wait for that person to get well again, and then, because it's only that person, it's all BS. It's all nonsense. So we have a rooted vulnerability due to the previous, and the problem is we accept this because we know this, it's familiar to us. It's how society ran before. So we've been born into the system. If you don't believe me how much we've been born into the system, can I just ask, at birth, did anybody sign a document that said that they agreed to be living in a country where we have to, every 4 years, elect or 5 years, elect a president? Did anybody sign that document on birth? Was anybody consulted on that membership? 5 years. So nobody signed that. I also didn't sign that document. So when we're told, this is the person that we've elected, now I'm going to be very controversial, but this is the guy that we've elected, you've got to have respect for your president. Did we agree to be living in that kind of society? Please do.
We adopted the Constitution.
We adopted.
The Constitution, our Parliament operates, our democracy will work.
Did you personally adopt the Constitution?
Developing the Constitution, and the Constitution was consulted in this country.
That is true.
We were given an opportunity for public participation. And I dare say that our Constitution is better than the American Constitution.
Absolutely.
We follow often what's happening with Trump and COVID, and you'll be shocked how supreme our Constitution is to their Constitution. So I support the Constitution, and supporting the Constitution, I support the issue of democracy and how our system of democracy works. Like in the States, any state can change their system of voting.
Yeah.
They've just brought in something now where parliamentarians will decide whether they accept the outcome of that state's election. So corrupt they also, with all the criticism of the country, if you
I see.
compare it,
Okay.
it's a good country for me because they have a good constitution.
Amen. Amen, sister. I see there was a hand next to you. I don't know if you want to do. Perfect. Perfect. Did you want to add? Okay. Yeah. I think I absolutely 1,000% agree with you that we can be very proud in this country about our constitution. And I think what makes our constitution so beautiful is the fact of the people who were there, often the legacies of the people who came up with the constitution really shows how that constitution came to be. I remember there was the inaugural speech of Justice Albie Sachs referenced so much of the constitution towards a beautiful relationship that he and the others had with Oliver Tambo, and spoke about how Oliver Tambo's legacy and thinking was such a fervent place. And I think that has a lot to do also in regards to why our constitution is the way we are at. However, I am asking you, do you see what I'm saying to you? Or what I'm asking from you is, it's not about should we reject necessarily things like, for example, the Constitution, or democracy and so forth. But the point is that we've got to be a little bit careful about how sometimes we become disempowered, often in systems that feel like they've always been and always will remain. And it's so important for us to be able to find our voice and our agency there. And one of the difficulties with the structure of the society in which we're living in now is because of the, how would you say, the charisma, it's often the charisma of an individual that paths your way towards empowerment or towards power, that we often miss the individual voices that are so essential to hear from ground level, of which, let's be honest, what we're doing here, it just says how important these types of conversations are. Does it make, am I winning with you? That's maybe the best question I can ask. Not yet.
Because I'm not a lawyer,
Yeah.
but I equip myself with law.
Yes.
And I often use law and the Constitution
Yeah.
to win my battles on where I am
I've got you.
being not
Yeah.
equally treated or whatever.
Yeah.
And I have familiarized myself with the Constitution.
Beautiful. Yeah.
I think that the way the Constitution is structured protects us in many
Absolutely.
ways than not.
Yeah.
And it is our responsibility to familiarize ourselves with the Constitution
Yeah. I've got you.
and claim those rights.
Amen. I've got like 2 minutes. Can I ask you to pause it for the Q&A? Is that okay? Okay. The thing is, and maybe we're witnessing it here, is often under immense pressure. You don't build leaders through times of peace. You build leaders through times of struggle. And one of the things that we have to our absolute pleasure from the 70s and the 80s is the great work of people like, for example, Sobukwe, people like Biko, Rick Turner, and then obviously the giants of Albie Sachs, Oliver Tambo. And there's something about that where how we fight against it, even if it's on our own level, is very important in regards to changing the culture and changing that through. And I agree in regards to the fact that at some point it's a political fight, or even if you like a legal fight. But what I also want to say to you, because that's the you I'm talking to now, is as you're working, as you're in your jobs, be careful a little bit about the power that might be taken away from you from the structures which you feel that you have to do, because you have to sign the job description, you have to do the PMDS. And as a result of that, because that's one of the big things that COVID and lockdown really taught us, was that we're actually really able to be innovative, creative, and brilliant with the ideas that come through. There were so many brilliant ideas. Okay, some of them were, opening shebeens in your backyard, but people survived on the back of that. But there was also so many people who took the plunge and started making money on their own. I remember that in lockdown, the opportunities for home cooked meals in the area that I was working at became quadrupled. But it was more than that as well. As it started that thing again around community, looking out for each other, the money generating within its own circles. And there was a real danger post-lockdown when we all went back into work that some of us would just carry on being allowed to work in the way that we were working, and especially around women empowerment. This was something I learned from a client, was the beauty of a hybrid approach meant that women could be at home and work, And the men started to get uncomfortable because the men wanted to wear their suits, or whatever the case might be. But it was such a liberating moment of not having to choose one identity or the other, but to be able to balance roles. It really did something beautiful in regards to that. And it's very ironic that the complainers of us moving out of hybrid back into, 8 to 5, sit at your desk is generally men. And I think to an extent, isn't that a beautiful thing that COVID's also given us, is the idea of working. People are not generally good at being micromanaged. Why are we micromanaging people? It takes responsibility completely away from individuals. Okay, I've now said my thing. So I hope that was good and that you got something from it. I think from my side, it's really about empowerment has to always be an internal process. And let's see the change that are ahead of us. I don't know if there's time for a question. I know that there was one potential one back. Yes, one question from the front. Yeah. Oh, one question allowed. It could be anybody. Does anybody have a question? Looks good. Do you want to ask the question? Perfect. Okay. Thank you so much for having me. Appreciate it.
Thank you, Mr. Daniel Den Hollander. There were some videos that I thought we'll be watching, but I'll send it to the people. There is some of Mr. Den Hollander's work on Daily Maverick that you can have a look at. Quite a controversial writer like Dr. Carmel van der Kerk. And thank you for concluding the session on men, and for us to have a deeper understanding of men and where we are in society. And it's so important that we have these discussions to try and understand the psyche of men, and not just all call them narcissists, because this is the word that have been running around for the last few years. And we need to change that and not just call a person narcissist. And I had a few discussions with Mr. Den Hollander, and I actually understand the deeper psyche of men after listening to some of his work. Please look on, subscribe to his channel on YouTube. You'll find a lot of information pertaining to the psyche of men and why men react in a specific way. And it's not just when they sit in the maintenance courts that they are narcissists, and that idea that is running around. So thank you so much for the last two sessions that you've been with us. We really appreciated all your inputs and so forth. It's just a pity we couldn't show all of the other videos and things that you have, but hopefully we'll be able to listen to you on YouTube and hear the other talks that you have. Please read the June Daily Maverick case of his views on the youth. Stunning article. And you'll get some more insight into this young man and how he is trying to change the system or the way South Africa is moving, and some of the dangers that he already identify, and how he takes it back into history in where we are and the time bomb that we are sitting on in South Africa. Thought-provoking. I really enjoy your work, and please don't stop writing. I really enjoy that, and always giving your information freely to the different departments. I know the Department of Social Development contacted me. They are busy trying to coax you into coming to present something to them too. 26 August is our next date. 26th of August, we will have the women over here. Then we will be celebrating women. So we will have some lineup of speakers. I will not be speaking. I will, in honor, as well as Mr. Opperman will not be speaking. So in honor of women, there will only be a female cast speaking at the 26 August community dialogue. Our special director in the National Prosecuting Authority, Advocate Bonikari Gamvu, will be in attendance. She already confirmed the attendance. She will be here, as well as some excellent world-class female speakers that will be speaking at our event. Dr. Shana Kemp from the Department of Education will be here. She will be speaking. And I wanted to ask Daniel to get his promoter to also come and speak. So maybe we'll be able to get hold of her in order for her to then also contribute and then speak at our Women's Day dialogue. That's the 26th of August, Saturday, 26th August, that we will have our dialogue. And I already spoke to some people in here that will be part of the lineup. So hopefully they will then also then speak at the Women's Dialogue, the 26th of August. For the rest of the program for September, we will see whether we will have a program, but in September, we might have a national webinar where we will then be speaking. We will then be speaking with other colleagues as far as the maintenance process in South Africa, where I will get some of my other colleagues that will also be part of a national webinar. That is September, where we, all the 10 senior maintenance prosecutors in South Africa will then join up via video link and then facilitate a session on maintenance in South Africa. There will also be a speaker, Kim Stevens. She will be in attendance, and she will address us as one of the female speakers on that specific day. I've spoken to somebody, some people over here that already agreed that they will also be speaking. So I will put up the lineup, and it will be on Quicket next week. I will make sure that is available. So please join us the 26th of August, and then we will make sure that we have our next community dialogue. The last community dialogue will be the 10th of December, Saturday, 10 December will be the last dialogue, then commemorating the 16 days of activism, where we will then conclude the 16 days of activism period in South Africa, and will then conclude all the maintenance work that we've done. Please look at the Lunch and Learn website. Mr. Opperman put a lot of effort in there. Everything is in there that you need in order to somehow navigate your way to the maintenance courts. So if you have some time, look at what is on the Lunch and Learn website, as well as on the divorce week that just finished yesterday, pertaining to the divorce settlements and all of those kind of things. Eugene, is there anything else that you want to add? Thank you so much for being in attendance so late in the afternoon, and have a safe journey back home.